Hey everyone, just getting set up here a second longer. We're going to wait for the advocates to come in, but it looks like we have all four jurors. Can everybody hear me?
Yep.
Great. Excellent.
Yes, Your Honor.
And counselors, if you're just joining us, you can keep your video and audio off. We're waiting for a few more people. We have all of our scoring jurors here. And we're just going to wait for the tournament directors to give us the all clear. So for now, you can keep your video and audio off. All right, so to facilitate just a check to make sure that we don't have any conflicts with our jurors, attorneys, could you please turn on your cams? You can keep your mics off for now, but just turn on your cams so that the jurors can see who you are. And jurors, if you recognize anyone, please send me a chat, let me know, so we can get you in another courtroom due to a conflict. And counsel for the defense, if you missed that for any reason, If you could, please turn on your cam just so the jurors can see who you are and make sure that there aren't any conflicts in the round before we sort of get the all clear from the tournament directors. Ms. Golden, is your co-counsel in the room?
She is not in this room. I can go ask her to join the chat at this time.
Oh, I see. So you're on the same cam, basically.
I'm sorry.
You're on the same camera. Is that what you're saying, Ms. Golden? Or you'll be using the same camera?
No, we're in two separate rooms.
Okay. Yeah, we might want her to get on the chat. Is this Ms. Phelps? Is that who we're waiting for?
Yes.
Excellent. She's joining right now.
Okay.
And counselors, for Mr. Ray, if you're on the chat, can you turn on your videos just so the jurors can get a look at you, make sure that there are no conflicts before we get the all clear? To each of the scoring jurors, if you see anybody that you recognize, just let me know via chat. Otherwise, you're set to wait, and you can turn off your cams or whatever you're most comfortable with. Absent anything from the jurors, it sounds like we're not going to have any conflicts in the round. So we're just waiting on clearing up a few things in the other courtrooms. I'm sorry we don't have any waiting music here, but we'll get started in just a few minutes. Sounds like we have one holdout courtroom. Sorry about this, folks, but they are sorting it out, so we should be able to get started very soon here.
Muted. Hey, Judge Fields. I might have to take some of your jurors away, unfortunately.
Sure thing. We've got 4 of them here.
Excellent. I'm going to take Aaron Hohol, and I'm going to ask you, Aaron, to sign out of this meeting, follow the same procedure, and go to courtroom number 2.
Okay.
And just text me when you're in, okay? And I may be back to take another person, Zach. So stand by.
Sounds great. We're conflict free here.
Thank you so much.
Phil, have you come to take somebody else? You're muted there, Phil.
It's been a long day, Zach. Judge or Booth, I'm going to be moving you, Juror Booth, to courtroom number 4.
Sounds good. I'll log in there.
Farewell, Juror Booth. This is a game of Survivor now.
And Judge Fields, I think I'm going to be adding one more to your crew. One sec.
Excellent. And counselors, just in anticipation of our third juror being added to the room, could counsel for the state and counsel for the defense turn on your cams just to make sure that there's not a conflict with this last juror? Thank you all so much. We should have the third juror here in just a second. Excellent. And so we have our third juror. We'll just make sure that there's no conflict here and wait for the all clear. But I think we are finally nearing the time to start.
I am here. I think I'm your third juror. I'm going to stop my video. I don't see any conflict, so I'll be ready to go.
Terrific. All right, folks, sorry about that very long delay. There's nothing quite like 15 minutes streaming on YouTube to make you question all of the bookshelves and everything else. We needed some waiting music. All right, can we begin, I suppose, with announcements of counsel? At this time, we'll formally call the state of West Carolina versus Timothy Ray, and let's begin with the prosecution. Please introduce yourselves.
Yes, Your Honor. Good afternoon. Zoe Phelps and Ryan Golden for the state of West Carolina.
Ms. Phelps, Ms. Golden, welcome. And counsel for the defense.
Your Honor, my name is Raina Salvatore, and I'm here for the defendant, Mr. Timothy Ray.
Good afternoon, Your Honor. My name is Caitlin Rao, and I also represent the defendant, Mr. Timothy Ray. And Your Honor, the defense does have some housekeeping items that we would like to discuss.
Could you just remind me of the pronunciation of your name? Is it Ms. Rowe? Am I saying that correctly?
Ms. Rao.
Rao. Excellent. Thank you. All right. We'll start with housekeeping, perhaps from the prosecution, and then we'll come back to the defense. Ms. Phelps or Ms. Golden, any housekeeping matters to address?
Yes, Your Honor. One matter, we would like to ask whether the court would like us to tender our experts pre-trial or during the direct examination of that expert.
Let's go ahead and save it until the direct examinations. Pursuant to the federal rules, you don't need to tender the expert if you don't wish to, but certainly no problem with handling it there. I think at that time, counsel for the defense will have a better sense of the witness's expertise. So let's save that for direct.
And then second, Your Honor, we would also request to pre-admit Exhibit 6. This is the autopsy report conducted on Nathan's body. It is stipulated in the case packet to be admissible, and we spoke with opposing counsel in advance, and they agreed.
And counsel for the defense, I assume that's correct?
Yes, that's correct, Your Honor.
Excellent. All right. With no objection, Exhibit 6 will be admitted into evidence. Counsel, go ahead.
Finally, Your Honor, we'd like to invoke the rule of sequestration of witnesses.
And Ms. Golden, does the state have any party representatives in the courtroom today?
Your Honor, we do have our expert, Dr. McLagreca. If defense counsel would like for experts to not be included in that rule, we would have no objection to that.
Counsel for the defense, what's your response as to Rule 615?
Your Honor, we're fine with both experts being in the courtroom today. We also have our expert here right now as well.
All right, with no objection, we'll constructively sequester all fact witnesses. Upon agreement of counsel, we'll allow the experts to stay constructively in the courtroom. Ms. Golden, anything further from the state?
That's all of the housekeeping matters for the state.
All right, counsel for the defense.
Thank you, Your Honor. First, we ask, may we freely use the screen share option during the course of this trial, or would you rather us ask permission each time we seek to use the screen share option?
Counselor, you can feel free to use screen share at your leisure. And just from my end, no need to ask permission to constructively approach a witness on this format. The courtroom is yours, counselors. I would just say that though you can't see him, we do have a diligent court reporter who is taking down everything that we are saying in the courtroom today, should the defendant wish to appeal in the future. So make sure that you make clear for the record what you're putting on the screen when you're approaching a witness with an exhibit.
Thank you, Your Honor. And also, we spoke with opposing counsel beforehand, and we both agreed that in light of the virtual nature of this trial, we just ask that if any party happens to lose internet connection, that the time is stopped until that individual is able to regain the internet connection.
Of course. And on that point, I just asked the timekeepers perhaps coordinate with each other. I believe you both have sort of a designation next to your name. Use the Zoom chat feature if you can, just to be sure that we don't get too far apart in terms of the team's time remaining.
And then, Your Honor, finally, just to make Your Honor aware, opposing counsel and we discussed before in our demonstrative exhibits, and there seems to be no objections to those.
Terrific. I assume that's right, Ms. Golden?
That's correct.
Excellent.
And my co-counsel will address our motions in limine.
All right, Ms. Salvatore?
Your Honor, before we proceed any further, just one more matter of housekeeping. In prior meeting with opposing counsel, we agreed to stipulate Exhibit 8 into evidence, assuming that they are still agreeing to that stipulation.
Ms. Golden, what's the state's position here?
Yes, we do agree to that stipulation as well. The state also does have motions in limine. Whichever order Your Honor would prefer to address them in. I just wanted to make sure you knew we also had motions. But yes,
Terrific.
we agree.
Of course. Okay, so we'll admit Exhibit 8 per party stipulation, and let's begin with motions from the state, and I'll come back to you, Ms. Salvatore, whenever
Yes,
you're
Your
ready,
Honor.
Ms. Golden.
My co-counsel, Ms. Phelps, will be arguing our motion.
Terrific.
Yes, Your Honor. We have a motion to exclude or the alternative motion. As Your Honor is well aware, this is a murder case of a 6-year-old child, and our primary fact witness, Detective Blake Booth, he conducted the interrogation after the defendant's arrest. And that evening, there's a transcript of that interrogation. And on page 44 of the electronic notebook, lines 29 through 30, Detective Booth says the following. He says he calls the defendant a piece of shit, and he says he'd be better off dead. And we move to exclude these statements under 401 and 403, because under 401, these statements don't have any tendency to make a fact of consequence of our burden, nor the state's, nor the defense's insanity defense more or less probable. And additionally, even if Your Honor were to find that it were relevant, it's substantially more prejudicial than probative.
Ms. Salvatore, let's address that motion one at a time. First, as to relevance, and then give me your response as to 403.
Your Honor, these statements are extremely, my apologies, extremely relevant because they go to the bias of the witness. In this case, this is the prosecution's lead witness who conducted the investigation. These comments are extremely probative because of his position and his interaction in this case. And as such, we would prefer that these, I apologize, that these statements be available to be questioned if that is appropriate.
All right, with that in mind, Ms. Phelps, well argued. I am not going to grant that motion at this time. You certainly can feel free to raise that objection again if the statement is elicited during trial. In the court's view, this is relevant evidence, tends to show the officer's bias. If you feel that it's being used excessively, Ms. Phelps, or if you feel that any probative value for eliciting that testimony is exceeded at any point by a danger of prejudice to the state's case, you can certainly raise that objection on 403 grounds again, but for now, motion denied.
Yes, Your Honor, that concludes the state's motions.
Excellent. Ms. Salvatore.
Your Honor, we have two motions. The first is concerning a picture of a belt in Exhibit 27 on page 104 of the record. My co-counsel, Ms. Rao, would be happy to share it with you if you would like to see it. We are objecting to this under FRE 1002 concerning best evidence. And while, yes, this is a photograph as the rule requires, this photograph of the belt would be used to show that this was, in fact, the belt that was used on October 17, 2018, when there is no evidence in this case to show that that was the belt that was used. As such, we are also objecting to it under 403. And furthermore, because of that, it would be more prejudicial than probative.
Ms. Phelps, your response?
Yes, Your Honor. Your Honor, Rule 1002, the best evidence rule, goes to authenticity. And on page 5 of the electronic notebook, stipulation 1 states that all exhibits are authentic.
Ms. Salvatore, any response there?
Your Honor, I stand by my objection.
All right. As to the best evidence objection, in this jurisdiction, it's the court's understanding that we are limited to the electronic notebook that counsel provided before trial. Per the authenticity stipulation, I think that this motion is best denied at this point in time. Again, on Rule 403, if you feel that the use of the belt at any point during trial becomes excessive, you certainly are free to raise that objection again, but the court will reserve any ruling on 403 grounds at this point.
Your Honor, just one more thing regarding the picture of the belt. If it is used, we do request, assuming that all the foundation is laid and that you do overrule the appropriate objections, that this picture be also be precluded from evidence because it shows a picture of a background of a child's room. It shows a lot of toys, and the defense is concerned that this will tug at the heartstrings of the jury.
Ms. Phelps?
Your Honor, the jury is going to be well aware in a few moments that this is a murder of a 6-year-old child. This is a murder case. I don't believe that the jury would be unable to handle or become emotionally inflamed by this picture. It simply corroborates the defendant's confession.
Ms. Salvatore, I think your objection on 403 grounds is well taken, but it's the court's understanding that both parties have stipulated that the killing took place in the child's bedroom. There's nothing in that photograph that I think runs afoul of 403's relatively high standard.
Yes, Your Honor. Would you like to hear my second motion?
Yes, please.
Okay. Concerning the second motion, it concerns the pretrial order number 7 on page 4 of the record, and it states that the defendant is competent to stand trial. We ask that this be precluded from the jury's knowledge, as this is a legal conclusion, and under 403, it does risk confusing the issues.
Ms. Phelps, perhaps the best place to start here is, do you intend to introduce any evidence about the defendant being found competent to stand trial?
We do not, Your Honor, and we have no objection to their request.
All right, motion granted, Ms. Salvatore.
Thank you.
Anything further from the defense?
Oh, my apologies. No, nothing further, Your Honor.
Excellent. Just a couple of quick housekeeping matters from me, and then we'll jump into openings. As I said, timekeepers try to coordinate throughout the trial, just so that everybody is aware. We'll take perhaps a moment just before the state has finished its case in chief to see what the time looks like from each side. We've already talked about formally tendering witnesses. Let's say that all witnesses have been pre-sworn at this time, so no need to ask for any of that. And the last thing is just, this is Saturday afternoon, and before we put the fourth wall back up, the court would ask all counsel to have fun. This is supposed to be a fun exercise, and I hope that it is exciting for you. I know your jurors want to see a fun round, so remember to enjoy what you're doing here. With that, if there's nothing else from the parties, let's begin with the state's opening.
May it please the court, counsel, members of the jury. The case you will hear today is about a man claiming to have lost his grip on reality when really he just lost his temper. On October 17th, 2018, the defendant, Timothy Ray, strangled and killed his 6-year-old son, Nathan, after Nathan spilled apple juice on the defendant's laptop. The morning of Nathan's murder, Nathan was eating a bowl of his favorite cereal, Frosted Flakes, at his dad's house. You see, Nathan's parents had recently separated, and so they were splitting their time with Nathan. The breakup had been rough, and Nathan's parents were not on good terms. In fact, Nathan's mom, Jessica Ray, had told the defendant, Timothy Ray, just a few days earlier that she was planning on filing for divorce. While Nathan was eating breakfast on the morning of October 17th, he reached for his glass of apple juice and accidentally knocked it over. The juice spilled on his father's laptop, ruining it. Little did Nathan know this innocent accident would cost him his life. When the defendant saw that the laptop was ruined, he immediately flew into a rage. He had already been feeling stressed about work that morning, and now this. He chased Nathan into the other room, and he forced Nathan to do physical exercises as punishment. He forced Nathan to do jumping jacks and high knees. And all the while, the defendant screamed at Nathan. Because Nathan was only 6, the sight and the sound of seeing his own father screaming at him made Nathan cry uncontrollably. The sight of his only son's tears somehow only made the defendant angrier. And when Nathan, exhausted, just couldn't do the exercises anymore, the defendant got even angrier that his son wouldn't do as he wanted. The defendant went to his room and he sat on his bed. But instead of calming down, the defendant grabbed a belt. He took that belt and he returned to his son. He hit Nathan with the belt again and again. And Nathan cried from the pain of being hit by that belt. Nathan cried out for his mom, and through his sobs, he told the defendant, "I hate you." By now, the defendant was furious. He took that belt that he had just used to beat his son, and he put the belt around his 6-year-old child's neck. He tightened the belt around Nathan's neck, preventing Nathan from breathing. And he pulled on that belt until Nathan was no longer crying. He pulled on that belt until Nathan stopped moving. He pulled on that belt until Nathan stopped breathing forever. Imagine the horror of that scene. A 6-year-old child with a belt around his neck, struggling desperately, trying to get free, clawing at his neck, kicking, flailing his arms, trying to loosen the belt from around his neck, trying to get his father to let him breathe. A child's face turning purple and then blue and then white as the life slowly drained from his body. After the defendant killed Nathan, he took Nathan's body and put it in his car and drove away from the home. He stayed in that car awake for almost 3 whole days. And at some point, he took his son's lifeless body, put it in a black trash bag, and took it to Brandywine State Park. There, the defendant dumped Nathan's body in a shallow grave. He left Nathan alone in the woods to rot. The day after Nathan's murder, his mom, Jessica, went to pick him up from school as planned, only to learn that her son wasn't there. And after the defendant didn't return her phone calls, she filed a missing persons report with the Skelton Police Department. Another day passed. On October 19th, 2018, 2 days after Nathan's murder, the defendant was stopped at a DUI sobriety checkpoint. After officers ran his license, they saw the missing persons report and they arrested the defendant. In the defendant's car were black trash bags, bottles of bleach, and a dirty shovel next to an empty car seat where Nathan should have been. The defendant was then taken back to the police station where he was interviewed by Detective Blake Booth. And in that interview, the defendant confessed to beating his son with a belt. He confessed to strangling his son with that same belt. And he confessed to hiding Nathan's body in Brandywine State Park. Skelton police eventually were able to locate Nathan's body in that shallow grave. And on that day, Detective Booth had to make a phone call that no one would want to make. He had to call Nathan's mom, Jessica Ray, and tell her that her son, her only child, was no longer missing, but was found dead. And that her ex, Nathan's own father, was the one who killed him. The state has charged Timothy Ray with the murder of Nathan Ray. We have the burden of proving this to you beyond a reasonable doubt. Beyond a reasonable doubt is a high burden for good reason. You have an important job here today, one that's not to be taken lightly. So how are we going to prove to you that the defendant is guilty of murder? One way is through the defendant's own words when he confessed to Detective Booth that he had strangled his son with a belt. But we're not going to ask you to just take the defendant's word for it. We're going to bring you not just what the defendant says, but what the evidence shows. So besides the defendant's confession, you will see all of the evidence that supports exactly how this crime occurred. Another way is through the defendant's own actions on October 17th, 2018. That moment of reflection when the defendant sat on his bed in the moments before killing Nathan. The way the defendant killed Nathan by strangling him over the course of minutes, not moments, not seconds, minutes. This evidence will prove to you beyond a reasonable doubt that the defendant murdered Nathan and is guilty of murder. The defendant, however, now claims that he cannot be guilty of murder because he was insane at the time he strangled his son with that belt. Insanity has a legal definition, and at the end of this trial, the judge will instruct you exactly what an insanity defense requires. The defense has the burden of proving that insanity defense by clear and convincing evidence. Now, clear and convincing evidence isn't as high of a burden as beyond a reasonable doubt, but it's still a really high burden. It's the burden the state has to meet in order to take your children away. Now, I anticipate in a few moments, the defense's counsel will get up here and will tell you all about the defendant's supposed lifelong struggle with mental illness. After the defendant was charged with Nathan's murder, his counsel hired a psychiatrist to evaluate him, and that doctor diagnosed the defendant with schizophrenia. But I want you to pay attention to the timing of these claims. After the defendant was charged with murder, he claimed that he had been experiencing delusions, that he had been having hallucinations, that he had been hearing voices. And the evidence to support these claims comes almost exclusively from the defendant's own mouth. And if you go back further, you'll see from the evidence that most of these claims are being made for the very first time, only after the defendant strangled his son, after the defendant was charged with murder, after the defendant had a motive to be mentally ill to avoid responsibility for his crime. Even if the defendant has schizophrenia, having a mental illness is not alone enough to meet the definition of insanity. The critical piece is that that mental illness be so severe that it makes a person unable to understand the morally right from the morally wrong. Ladies and gentlemen, members of the jury, there's a difference between being unable to understand right from wrong and being unable to simply control your own temper. The evidence will show you that on October 17th, 2018, the defendant understood the wrongfulness of his actions when he strangled his son with a belt. You'll hear from the evidence all of the steps the defendant took to cover up what he had done to Nathan in the moments and days after he strangled his son. Timothy Ray did something the rest of us can't comprehend. That doesn't mean he's legally insane. At the end of this trial, after you've seen all the evidence, we will be asking you to find the defendant, Timothy Ray, guilty of murder. Timothy Ray claims to have lost his grip on reality, but really, he just lost his temper. And Nathan Ray lost his life because of that. We look forward to presenting our case to you.
Thank you, Ms. Golden. And Ms. Salvatore, whenever you are ready, you may proceed.
Your Honor, if I might have one moment.
Of course, take your time.
You can hear me?
Yes, you sound, your sound is coming through.
Sorry, one moment. Sorry.
Ms. Salvatore, I believe that you're muted now. So sorry about that.
Thank you, Your Honor.
All right, whenever you're ready. It's a new jurisdiction for all of us.
Overlooked, overwhelmed, overpowered. Overlooked. For 32 years, for all of Timothy Ray's life, his symptoms, his sufferings, and his schizophrenia have gone unnoticed. Overwhelmed. Since Timothy was 10 years old, he had been hearing voices, and these voices overwhelmed him. They crowded his head until he could not think for himself. overpowered. On October 17th, 2018, that is exactly what happened. Those voices crowded his head and controlled his actions. They commanded him again and again, strangle your son. But Timothy, no matter how much he loved his son, could not fight those voices. And Nathan Ray, age 6, died because it is impossible to control a mental illness like schizophrenia. Good morning, good afternoon. My name is Raina Salvatore, and I, along with my co-counsel, Ms. Caitlin Rao, will be representing Timothy throughout this trial. And off the bat, I'd like to state 2 things. That 1, this is a trial about a father who caused the death of his son. We are not denying this. And 2, it is about schizophrenia. Schizophrenia is a brain disease, and it can destroy a person's ability to think. But the prosecution is contending otherwise. They are seeking to prove that Timothy intended to cause the death of his son beyond a reasonable doubt, and they will fail to meet that burden. But we, the defense, do also have a burden in this trial, and we will meet it. We will show you through clear and convincing evidence that 1, Timothy has schizophrenia, and he had it on October 17, 2018. And 2, that because of Timothy's schizophrenia, he is unable to understand the gravity of his actions. Now, before we proceed any further, I would like to talk to you a little bit more about schizophrenia. Schizophrenia is a brain disease, and it can destroy your ability to think. It can make you lose touch with reality. It can cause you to hallucinate, to see things that are not there. It can cause you to experience paranoia so extreme that you lose your trust and faith in the people who love and care about you. And it can also cause you to hear voices that you and you alone can hear, voices that overwhelm and overpower you. And this is what happened to Timothy. Overlooked. Now, in order to understand Timothy, we first need to talk about Timothy's childhood and his mother. His mother, who abused and neglected him, who left him alone for hours at a time, who made him take ice, cold, freezing baths, who refused to take care of a young child, and who refused to feed him. Timothy did not have a normal childhood. And later, when Timothy turned 10, he would begin hearing voices that he and he alone could hear. No one else could hear them, and no one noticed. Later, Timothy joined the army. He wanted to serve his country, but the army discharged him. They found that he was hallucinating, and because of this, they found him not fit to serve. After being discharged from the army, Timothy would see his doctor on a number of occasions, and she would recommend that he get psychiatric care. But unfortunately, he did not, and he became sicker and sicker. Eventually, his wife would leave him because of the effects his illness had on him. For years, Timothy battled and he fought, but on October 17, 2018, he lost. He lost to voices that were male, to voices that were powerful, to voices that commanded him over and over again, strangle your son. Timothy could not fight these voices, and Nathan died. Overwhelmed. Now, the first witness that you will hear from the defense is Officer Peyton Wentz. And Officer Wentz will tell you that she is a police officer here in Skeleton County. She will tell you about the mental health training that she underwent and about her encounter 2 days after Nathan's death. She will tell you that she immediately noticed his strange, paranoid, and erratic behavior. She will tell you that he told her on multiple occasions that, "Are you in the CIA?" and told her that he was a terrorist that the CIA was after. And she knew that because of this strange, erratic, and paranoid behavior, that Timothy needed a medic. But Detective Blake Booth, the prosecution's witness, will disagree. You will learn that Detective Booth purposefully overlooked these symptoms of strange, paranoid, and erratic behavior that he ignored when Timothy asked him on multiple occasions, "Are you in the CIA?" You will learn that he ignored these overwhelmingly apparent paranoid, strange, and erratic behaviors that Timothy was showing that required a medic. Overpowered. On October 17, 2018, Timothy heard voices. And Dr. Shane Riley, an extremely qualified forensic psychiatrist, will tell you that this is a symptom of schizophrenia. In fact, she will tell you that Timothy's other symptoms of paranoia, delusions, and hallucinations are all symptoms of schizophrenia. She will tell you 3 final important things. That 1, Timothy has schizophrenia. That 2, Timothy had schizophrenia on October 17, 2018. And 3, that because of Timothy's schizophrenia is a disease that can impair a person's, that can destroy a person's ability to think, to distinguish right from wrong, and to have intent. Overlooked, overwhelmed, overpowered. Overlooked because for 32 years, Timothy's schizophrenia has gone unnoticed. Overwhelmed because those voices crowded Timothy's head till he could not think for himself. And overpowered because those voices are what controlled Timothy on October 17, 2018. It is a tragedy that Nathan Ray died. But Nathan is not a victim of his father. He is a victim of his father's schizophrenia. And it is because of this that the prosecution will fail to meet their burden in proving intent beyond a reasonable doubt. And when they fail to meet that burden, the law will demand that you, the jury, and the fact finders in this case find Timothy not guilty. Thank you.
Thank you, Ms. Salvatore. And counsel for the state of West Carolina, whenever you are ready, you may call your first witness.
Yes, Your Honor. Prosecution calls Detective Blake Booth to the stand.
Detective Booth, I just remind you that you've been previously sworn.
Good afternoon, Detective Booth. I know we've gotten a chance to meet, but would you please turn and introduce yourself to the jury?
Yes, my name is Detective Blake Booth.
What do you do for work?
I work for the Skelton Police Department.
How long have you worked for Skelton Police Department?
Over 20 years. I think we're coming up on 25 here pretty soon.
And what's your current position with Skelton PD?
I'm a detective in the homicide division.
How long have you been a detective?
I've been a detective for about 8 years now.
Detective, let's turn to your involvement in this case. What was your role in this case?
Yes, ma'am. My role in this case was I was assigned to be the lead detective on the missing persons case of Nathan Ray.
Who was Nathan Ray?
Nathan was a 6-year-old boy from Skelton.
Detective, I'd like to show you Exhibit 29. It's on page 106 of the digital notebook that you were provided. Would you please turn to that?
Yes, ma'am.
Do you recognize this?
I do.
What is it?
This is a photograph of Nathan.
Who gave you this photograph of Nathan?
Nathan's mother, Jessica, gave me this photograph when we first opened the missing persons case.
Is it a fair and accurate depiction of Nathan as he appeared before October 17th, 2018?
Yes, ma'am, it is.
Your Honor, this time, state offers Exhibit 29 into evidence.
Ms. Rao, any objection?
Yes, Your Honor. This evidence should be excluded under Federal Rules of Evidence 401 and 403. First, regarding the relevance grounds, this picture has no relevance. The identification of the victim is not disputed, and it has never been disputed. But furthermore, under Federal Rule of Evidence 403, the probative value of this evidence is substantially outweighed by the risk of unfair prejudice because, of course, showing a picture of a 6-year-old boy is likely to inflame the passions of the jury. And so we ask that this evidence is excluded.
Ms. Golden, your response.
Yes, Your Honor. The reason we're here today is because of Nathan Ray. And it's a little bit absurd to say that a jury in a murder investigation shouldn't be entitled to see a photo of the victim of the murder they're here to hear about and decide. It's extremely relevant to the case, and it's not unfairly prejudicial. The jury knows this deals with a child, and they should be allowed to see the child that they're hearing about today.
All right, I think I've heard enough. Ms. Rao well argued. In the court's view, this is certainly relevant, so your 401 objection is overruled. The 403 question is a bit closer, but in the court's thinking, if this were an attempted murder trial, the victim would be able to take the stand. There's no reason with this photograph specifically that we should fear a danger of sort of unfair prejudice in showing the victim's face. So objection overruled there as well, but preserved for appeal, Ms. Rao. Exhibit, remind me the number there, Ms. Golden?
29.
29 is admitted. You may proceed.
Your Honor, may we show it to the jury?
You may.
Detective, who is your main suspect in this case?
My main suspect in this case was Nathan's father, Timothy Ray.
Why was that?
Well, when the missing persons case was opened, I learned that he and his, I guess, then separated estranged wife, Jessica, had been having some marital troubles. Typically, in a missing persons case involving a child, if there have been marital issues, we usually start with the parents.
How did you eventually come into contact with the defendant?
Yes, ma'am. I received a call on October 19th around 9 p.m. That the defendant had been pulled over at a sobriety checkpoint. The officers there had run his license and registration and learned that he was connected with Nathan's missing persons case. So I received a call, and I briefly went out there and then had the officers shut down the sobriety checkpoint and bring him back to the police department.
After the defendant was brought back to the police department, were you able to interview him?
Yes, ma'am, I was.
What did the defendant tell you in that interview?
The defendant told me that he confessed to killing his son and burying his body in Brandywine State Park.
Before this investigation, had you previously met the defendant?
Yes, ma'am, I had.
What were the circumstances of that interaction?
Our children played on the same soccer team, so I would see him at the games on the weekends. Occasionally, I would try and speak with him. He was never very social and didn't really, interact with me that much. You could barely call them conversations, but that was the extent of it.
How, if at all, did this previous interaction affect your investigation in this case?
It did not.
Detective, the man that you interviewed on October 19th, 2018, is he here in the courtroom today?
Yes, ma'am, he is.
Would you please identify him based on his location in the courtroom and an article of clothing?
Yes, ma'am. He's sitting at the defendant's table next to his attorneys. He's wearing an orange jumpsuit and handcuffs.
Your Honor, may the record reflect that the detective has identified the defendant in open court.
All right, I'm not sure why Mr. Ray is still in handcuffs, but the record will so reflect. You may proceed, Ms. Golden.
Thank you. And my co-counsel can stop sharing the photo at this time. Thank you. Detective, I want to talk a little bit more about your interactions with the defendant on October 19th. What was your perception of the defendant's emotional state during this interview?
He was, obviously very somber. He was sometimes crying off and on, just very quiet, but still was answering the questions.
Besides his emotional state, was the defendant otherwise behaving abnormally?
No, ma'am, not so much. There were a couple of times he asked if I were in the CIA. If I was in the CIA, I continually told him, no, I'm not in the CIA. But other than that, there was nothing that stood out.
What were your thoughts when he asked you if you were in the CIA?
Well, when I'd gone out to the sobriety checkpoint, I'd spoken with the officers and had learned that he'd been asking them those same questions after they had taken his license and registration. So with that in mind, the timing seemed a little bit suspicious. And
Detective, what about your interactions with the defendant made you think he might not have understood what was going on?
Nothing about my interactions made me feel like the defendant didn't understand what was going on.
During your, I believe you said about 25 years on the force, have you come into contact with mentally ill people before?
Yes, ma'am, I have, with some frequency.
Did anything about those previous interactions with other people come to mind when you interacted with the defendant?
No, ma'am.
And from your previous impressions of the defendant when you interacted socially at your children's soccer games, did you ever think that the defendant might be mentally ill?
No, ma'am, I didn't.
How did that opinion change throughout the course of your investigation?
That opinion did not change throughout the entirety of the investigation.
Detective, let's talk some more about your investigation. After you interviewed the defendant and he confessed to you, what did you do next?
We went to Brandywine State Park to see if we could recover Nathan's body, and then I proceeded to look for evidence after that.
Where did you find Nathan's body?
We found Nathan's body in Brandywine State Park, as the defendant said.
After you located and recovered Nathan's body, was there an autopsy done on his body?
Yes, ma'am, there was.
Are you familiar with the results of that autopsy?
Yes, ma'am, I reviewed it.
What were they?
It was determined by, in the autopsy report, that Nathan had died of asphyxiation, and there was evidence of bruising around his neck consistent with being strangled, and it went on to say likely by a belt.
Detective, if you would refer in your digital notebook to Exhibit 6 on page 53, is this the same report that you saw?
Yes, ma'am, it is.
Was this report consistent with what the defendant confessed to you?
Yes, ma'am, it was.
And for the record, Exhibit 6 has already been pre-admitted pre-trial. Detective, did you find any other evidence in your investigation that matched what the defendant told you?
Yes, ma'am, we did.
Where was that?
We found some at the defendant's home, and then we also found some in the back seat of his car.
Did you photograph or collect these pieces of evidence?
Yes, ma'am.
Would you recognize those photographs if I showed them to you?
Yes, ma'am, I would.
Detective, now I'd like for you to turn in your digital notebook to Exhibit 10 and then Exhibits 18 through 28. Do you recognize these exhibits?
Yes to Exhibit 10, and then yes to the rest of them.
What are these exhibits?
These are all photographs of the evidence that we collected throughout the investigation.
And are these photographs fair and accurate depictions of the evidence you photographed and collected during your investigation?
Yes, ma'am.
Your Honor, at this time, the state offers Exhibit 10 and Exhibits 18 through 28 into evidence.
All right, Ms. Rao, any objection to those 11 exhibits, 10 or 18 through 28?
Yes, Your Honor. We'll begin with exhibit number 10, which I believe is the cell phone picture.
Of course.
Evidence should be excluded under Federal Rule of Evidence 1002, which is the best evidence rule. This is a photograph of a cell phone, and the prosecution is seeking to admit this evidence to prove that this evidence did in fact come from Mr. Ray's phone. And so therefore they are required to produce his actual cell phone. And then furthermore, this evidence is also hearsay under Federal Rules of Evidence 801. These searches were made outside of the courtroom by Mr. Ray, and the state is offering them to prove that Mr. Ray did in fact make these searches.
All right. With those objections in mind, Ms. Golden, what are your responses?
Yes, Your Honor. As to the objection to the best evidence rule, again, it's stipulated in this case that all exhibits are authentic, and as a practical matter, we're not able to bring the defendant's cell phone into court today. As well, the objection based on hearsay, Your Honor, this is a statement of a party opponent, and therefore it is not hearsay.
Right. As to the best evidence rule, the court is going to overrule that objection. Ms. Rao, do you have a good faith basis belief that any evidence will show that these searches weren't made by the defendant, or is this otherwise admission by a party opponent?
Your Honor, we do have objection to these screenshots, and we don't have, we do have a good faith basis to challenge whether these screenshots did in fact come from Mr. Ray's phone. If Your Honor see the pictures of the screenshots, you will see the significant time difference between the two photos. I believe it's about 37 minutes. So there is nothing on the actual screenshots that indicates that these photos did in fact come from Mr. Ray's phone. The only thing we have is the settings page, which was taken 37 minutes later. And so therefore, we do object that these photos did in fact come from Mr. Ray's phone.
Ms. Golden, what do you have to say to that?
Yes, Your Honor. There is no evidence to suggest that anyone but the defendant had access to this cell phone between the time of even Nathan's death and the time that the cell phone was recovered. The searches were made the day after Nathan's death. And while I understand opposing counsel's statement about the 37-minute difference, during the time that the cell phone was seized, the only people in possession or custody or control of the cell phone were Skelton police. There's no evidence that anyone else had access to the cell phone at any other time. So we have no reason to believe anyone but the defendant, who's listed as the owner of the phone, which the searches were made on. We have no evidence to suggest anyone other than him made these searches.
Ms. Rao, one final response if you'd like it.
Yes, Your Honor. All we have is Detective Blake Booth's word that these came from the phone. And as Your Honor has previously ruled in the preliminary hearing, or heard from Detective Booth, there are serious issues to his credibility. And so therefore, we do object to the admission of these evidence purely on the grounds that Detective Blake Booth said that these screenshots did in fact come from Mr. Ray's phone.
All right, the court is going to admit Exhibit 10. 801D2 seems to control here. This is an admission by a party opponent. The standard for showing that is typically a preponderance standard. Ms. Rao, if you are able to sort of introduce sufficient evidence by the end of trial that suggests that the state hasn't met its preponderance burden to show that these statements were in fact made by the defendant, then certainly feel free to renew your objection and the court would entertain it at that time. But at this time, conditionally, the court is going to admit Exhibit 10 into evidence. Ms. Rao, you said you also had objections to Exhibits 18 through 28?
Yes, Your Honor, I'll do them in the bunches of what the exhibits are. So 18 through 21 are the photos of the Brandywine State Park, and we object to this evidence on the grounds of Federal Rule of Evidence 401 and 403. So first, relevance, there's simply no dispute as to where Nathan's body was found. And so therefore, these photographs taken together are not relevant to this case. But furthermore, under Federal Rule of Evidence 403, this evidence is likely to inflame, once again, the passions of the jury. Seeing where a body was buried, of course, is going to be, invoke a lot of emotions from the jury, but furthermore, it's also cumulative. If Your Honor does allow the state to introduce this evidence, they should be limited to just one photograph, because there's no need to have, by my account, I believe it's 3 photographs of where Nathan's body was found.
Ms. Golden.
Yes, Your Honor. As to the objection to Rule 401, this is extremely relevant evidence. Again, we're here today because of Nathan's murder. Nathan is the victim of the murder. The jury is here today to decide. These photos are extremely relevant to what the state has to prove in order to prove the murder. And moreover, as to the objection to Rule 403, that probative value of the photos is not substantially outweighed by a danger of unfair prejudice. Your Honor, these photos, there's nothing gory about these photos. They don't show in graphic detail the state of Nathan's body. All you can see of Nathan is a single tennis shoe sticking out of the bag. There's nothing about these photos that would inflame the jury or make them decide this case based on emotion. We know that this case involves a dead 6-year-old, and there's no reason why the jury should not be able to see these photos. And then finally, as to the objection that it is cumulative, these photos are not so cumulative to be unduly repetitious. They show different angles and different depictions of the crime scene.
Ms. Rao, any response?
Yes, Your Honor. Once again, regarding the cumulative argument, it's unclear to me why the state needs to introduce 3 different angles of where Nathan's body was found. Once again, the defense has never disputed where Nathan's body was found. In fact, the prosecution learned that information from our client because he admitted that. So this information is just simply not relevant, and there's no need to have 3 photographs of where Nathan was buried introduced to the jury.
All right, counselors. The objection as to relevance is overruled. At a certain point, Ms. Golden, it does seem that showing a 6-year-old boy's body from every potential angle is unnecessarily cumulative. I'm not sure what the additional probative value would be. So at this point, the state is going to admit Exhibit 18, and unless you can show further need, Ms. Golden, or further probative value, Exhibits 19 through 21 will be excluded.
That's perfectly fine, Your Honor.
All right, Ms. Rao, I believe that leaves Exhibits 22 through 28. Any objections there?
Yes, Your Honor. Regarding the photos of the back seat, which I believe are 22 through 25, once again, we seek to exclude these pictures on 401 and 403 grounds. So once again, a picture of a back seat is not relevant to this case. The only issue in this case is the mens rea of Mr. Ray. And so the back seat of his car is just simply not relevant. But furthermore, if Your Honor disagrees, we do seek to request that the prosecution is only able to admit one of these photographs, because it would be cumulative to allow 3 photographs of the back seat to be introduced. And furthermore, as Your Honor can see in some of these photographs, we do see children's toys in the back seat, which is extremely prejudicial under Rule 403.
Ms. Golden?
Yes, Your Honor. These photographs first are relevant as to what the defendant did, the actions he took after he strangled his child. And furthermore, one of the things that the state needs to show is that Detective Booth took reasonable steps to confirm what the defendant confessed to him in his interview. And the photos of the back seat with the bleach and the trash bags, as well as the shovel, corroborate in connection with the other evidence we have. These all together tend to corroborate what the defendant confessed to Detective Booth. So these are relevant. Second of all, these photographs are not substantially more prejudicial than probative, given that relevance. Your Honor, again, the jury is well aware that this is a murder case involving a 6-year-old child. Seeing the sight of a couple toys next to these items will not inflame the jury's emotions and make them unable to decide the case based on the evidence that they hear. Finally, again, these photographs are not so cumulative to be unduly repetitious, even more so than the last batch of photos. These photographs show different pieces of evidence from different angles in different degrees of detail, and so they are not unduly repetitious.
All right, counselors. The court is going to admit exhibits 22 through, I believe it's 26, which is the final photo from the backseat of the car. I agree, Ms. Golden, this is slightly different than showing the boy's body and may offer some circumstantial evidence of the defendant's state of mind. So the items found in the backseat of the car, those photos are admitted. Ms. Rao, that just leaves exhibits 27 and 28. Do you have any objection to those?
Your Honor, I have no objection to Exhibit 28, but I do have an objection to Exhibit 27, which is the belt. This should be excluded under Federal Rule of Evidence 403 because the probative value of this evidence is substantially outweighed by the risk of unfair prejudice. In the background of this photo, we can see that I believe it's a toy box, says Nathan's Express. We see a teddy bear, we see a dollhouse, and this is exactly what Federal Rule of Evidence 403 is meant to preclude, are things like this that could inflame the passions of the jury and tug at their heartstrings when they see little boys' toys in the background. And so we ask that this photograph is excluded.
Ms. Golden, I believe I had addressed this in a pretrial order, but any response to Ms. Rao's objection on 403 grounds?
No, Your Honor, besides my previous response that the jury knows that this is a murder of a 6-year-old child, I have no further response.
All right, the court will admit exhibits 27 and 28. So just to recap, exhibit 10, 18, and 22 through 28 are all admitted into evidence. You may proceed, Ms. Golden.
Yes, Your Honor. Detective, Your Honor, may we show these to the jury?
You may freely publish, yes.
Thank you. Detective, let's talk about the evidence you found at the defendant's home first. What did you find at the defendant's home?
We found the apple juice spilled on the counter, as Mr. Ray told us happened in his account that broke his laptop. We found the belt in Nathan's room that the defendant said he used. And then we also found his cell phone as well with his search history.
And which exhibits depict the things you found at the defendant's home?
Yes, ma'am. Exhibit 10 is the search history on the defendant's phone. Exhibit 27 is the belt that was found in Nathan's room, and Exhibit 28 is the apple juice that was found on the counter.
And did these match what the defendant confessed to you?
Yes, ma'am, they did. He didn't say anything in the interview about his phone, but the 27 and 28, the belt and apple juice matched his account exactly.
What did you find on the defendant's phone?
We found 3 search queries on his internet app, each with a different query that was made the day after Nathan was killed.
And what else did you find on the defendant's phone?
We also found the settings page, which indicated through the Apple ID function that the phone was belonged to the defendant.
Based on your investigation, all the other evidence you found, and what the defendant told you in his confession, who did you believe made these searches?
I believe Mr. Ray made these searches.
Detective, would you please read these searches to the jury?
Yes, ma'am. Starting from the bottom and going up, it's will bleach destroy a body, how to get rid of a body, and countries that don't extradite for murder charges.
What was the date of those searches?
October 18th.
Now let's talk about the evidence you found in the defendant's car. What did you find in the backseat of his car?
Yes, ma'am. In the backseat of his car, we found bleach, bottles of bleach, a shovel, and some black trash bags.
And were these exhibits 22 through 26 for the record?
Yes, ma'am. These show what we found in the defendant's backseat.
What was significant about the bleach to you?
The significance about the bleach is it corroborated the search query that was on Mr. Ray's phone where he was searching if bleach destroyed a body.
And what was significant, if anything, about the black trash bags?
The black trash bags appeared to at least be substantially similar to the ones that we found, to what we found Nathan's body in.
Now, let's talk about how you found Nathan's body. Where did you find Nathan's body?
Yes, ma'am. We found Nathan's body in Brandywine State Park.
And for the record, was this exhibit 18 that depicts the scene?
Yes, ma'am. That is how we found the body.
What was significant about the way that the body was disposed of?
Well, it was obviously out in the woods in Brandywine State Park. It was buried in, as you can see, I don't even know if you can call it a shallow grave. It's just got a little bit of dirt on top. And you can see Nathan's tennis shoes there sticking out from the top. So it corroborated where Mr. Ray said he had left his son's body.
Thank you, Detective. My co-counsel, you can stop sharing those. Detective, have you investigated murders before this case?
Yes, ma'am, I have.
Is it something you see commonly that someone loses their temper and kills another person?
Yes, ma'am, with some frequency that happens often.
Does the fact that the person lost their temper mean they didn't understand that killing the person was wrong?
No, ma'am.
Your Honor, leading.
Ms. Golden, why don't you try to rephrase the question? Objection
Yes,
sustained.
Your Honor. Yes, Your Honor. What effect does the fact that a person has lost their temper have on the person's ability to understand the difference between right and wrong?
Objection, Your Honor. I don't believe that this witness is qualified to answer that question. It's calling for an expert opinion on whether or not somebody who loses their temper can act in such a way.
Ms. Golden?
Your Honor, this is based on the detective's prior experience investigating murders unrelated to this one. It's a general question about what common issues arise in murders.
Ms. Rao?
Your Honor, once again, the Detective Blake Booth cannot answer the question of what effect it has when somebody loses their temper and what that causes them to do. That calls for a medical conclusion. And so this witness is not qualified to answer that unless, of course, opposing counsel would like to tender him as an expert witness in that area.
Ms. Golden, I assume you don't intend to do that. Is that correct?
No, Your Honor, that's not our intent.
This does seem to run dangerously close to speculation. I'm not sure that you've laid a foundation that Detective Booth can speak to the defendant's state of mind. Let's try to keep his testimony to his experience, what he can say he's seen given his years on the force. I'm not sure that this is rationally based on the witness's perception, though. So objection sustained.
Yes, Your Honor. Detective, from your experience investigating murders, what state of mind is necessary to charge someone with murder?
Generally, they either have to have intentionally killed somebody, or they have a disregard for human life.
What can happen when someone loses their temper?
From my perspective in my homicide investigations, it can cause somebody sometimes to commit murder.
Pass the witness.
All right, Ms. Rao, you may proceed with cross whenever you're ready.
Thank you, Your Honor. Detective Booth, you're the only person who searched Mr. Ray's phone, correct?
I believe so, yes, ma'am.
And isn't it correct that you did not find anything in Mr. Ray's search history, such as symptoms of schizophrenia? Yes or no?
Yes, that's correct. I read the 3.
And what about how to trick a cop? Did you find anything like that?
No, ma'am.
And what about how to get away with murder because of insanity? Did you find anything like that?
No, only countries that don't extradite for murder.
Detective Booth, turning to your previous testimony in this case, you previously testified on December 18th, 2018, correct?
Yes, that's correct.
And at that time, you knew that Mr. Ray had asserted an insanity defense in this case, correct?
I believe so, but I don't recall when I learned that.
Okay. And you knew that your testimony would be used in the first-degree murder prosecution of Mr. Ray, correct?
I knew it was for the preliminary hearing.
Okay. But you knew that the reason why you were being called for a preliminary hearing was because Mr. Ray had been charged with first-degree murder, correct?
Yes, ma'am, that's correct.
And the testimony you gave was under oath, yes?
Yes, ma'am.
And you understood that oath, didn't you?
Yes, ma'am.
And during that testimony, you were asked if Mr. Ray had asked you if you were in the CIA. You recall that question, don't you?
Yes, ma'am.
And you recall your response where you said, no, he never said anything about that. You do recall that, correct?
Yes, I think I said that on that day.
And so on direct, when you testified that Mr. Ray had asked you about if you were in the CIA, that was true, wasn't it?
Yes, it was.
And so therefore, the testimony you gave in this preliminary hearing was not true, correct?
No, I don't think I recalled it at that time.
Okay, Detective Booth. Now, turning to the Skeleton County Police Department's directives on collecting evidence, you've read those, correct?
Yes, ma'am.
And so you are aware that they say that all interviews should be recorded with video and audio, correct?
Yes, ma'am.
And that's important because the recordings are evidence, correct?
Yes, ma'am, they can be.
And those police directives also say do not destroy evidence, right?
Yes, they tell you not to destroy evidence.
And after your interview with Mr. Ray, you had 30 days to request the video of your interview before it would be erased forever, correct?
Yes, ma'am.
And just to be clear, you knew about this back in 2018, correct?
I'm sorry, knew about what?
Knew that if you hadn't requested this audio or video recording within 30 days, that it would be erased forever.
Yes, ma'am.
But Detective Booth, isn't it true that you did not request the recording of your interview with Mr. Ray?
Yes, ma'am, because it doesn't say in the directives we have to preserve for forever. It says that we have to have an audio and visual recording, and then it is erased after 30 days unless otherwise asked. So the directives are guidelines. They don't tell us that we have to preserve the audio and visual.
Detective Booth, but you never requested the audio or video within 30 days, correct?
Per the directives, I was not required to, so no.
In fact, didn't you say that you didn't request the audio or video because it was clear to you that the defendant was guilty of murdering his son?
Yes, ma'am.
And Detective, so you just said you're familiar with these rules, so I have to ask you, do these rules just not apply to you?
No, ma'am, like I said earlier, the directives do not require we preserve evidence forever. It only requires we have an audio and visual recording. And we did have that audio and visual recording for 30 days, so there was no need to go any further.
But surely, Detective Booth, in your, I believe you said almost 25 years of experience, you know that the importance of preserving evidence is not for a 30-day period. The point of preserving evidence is for a trial, correct?
Yes, ma'am. That's why we have the transcript still.
And Detective Booth, isn't it true that that video would have shown the members of the jury who are here today how Mr. Ray looked that night you interviewed him?
It would have. I'm here today, so I can tell the jury if they'd like to hear.
And Detective Booth, wouldn't that video have shown Mr. Ray's demeanor?
Yes, and I can tell the jury about that too.
And wouldn't it have shown that if Mr. Ray was able to make eye contact with you?
Yes, ma'am, and I can tell the jury about that as well.
And wouldn't the video have shown Mr. Ray ask you, they told me to do it, they told me she tricked him?
Yes, ma'am, and they can see that in the transcript as well.
In Detective Booth, just to be clear, you never bothered to ask Mr. Ray who they were, did you?
No, ma'am, not at that time because I was trying to learn what had happened.
Well, he mentioned they 6 times, so isn't it a big deal if a mysterious they told Mr. Ray to kill his son?
Potentially, yes, ma'am, but also we see a lot of criminals try and get away with saying other things when they're being interrogated because they're trying to avoid responsibility or they're not being fully forthcoming. So I was there to find out what had actually happened that night.
Well, Detective Booth, what if this they helped Mr. Ray? Wouldn't it, kill Nathan? Wouldn't it surely be relevant to your investigation to find out who this they was?
Yes, ma'am, but there was no evidence there was anybody else in that house.
Or did you just not ask Mr. Ray who this they was because you knew that Mr. Ray was referring to the voices in his head? Isn't that right, Detective?
No, I don't believe I knew he was referring to voices in his head at the time, no, ma'am.
But Detective Booth, you still gave Mr. Ray a waiver of rights form, correct?
Yes, ma'am, that's standard practice.
Is it standard practice for the Skeleton County Police Department to give somebody a waiver of rights form after they've asked 6 times if you're in the CIA?
He hadn't asked me if I was in the CIA at the time I gave him the report or the form.
Well, Detective Booth, didn't you just testify in direct examination that before you started your interview with Mr. Ray, some of your fellow police officers had told you that he had asked if they were in the CIA?
Yes, ma'am, and they also told me that he had asked after they had taken his license and registration, and so it seemed suspicious even then.
Right, so therefore you did in fact know when you gave Mr. Ray the waiver of rights form that Mr. Ray had been asking if people were in the CIA,
yes,
correct?
ma'am. He asked me if he had already asked me if I was in the CIA.
And so, Detective, instead of getting Mr. Ray the help that Officer Wentz thought he needed that night, didn't you in fact say to Mr. Ray, "You're a piece of shit, Tim"? You said that, correct?
Yes, ma'am, I said that. I regret that because it wasn't professional, but I just heard a very unfortunate confession and description of what had happened. And when I had shown up at the sobriety checkpoint and asked Officer Wentz if he needed an EMT, if he was injured, Officer Wentz said no. So I didn't see any reason at that time to get him any help.
And even though Officer Wentz told you that he believed, based off of his mental health training, that he needed medical help, didn't you in fact say to Mr. Ray that, quote, he would be better off dead? You said those words, correct?
Yes, ma'am. Again, like I said, I regret being unprofessional.
All right, any redirect? Ms. Golden.
No redirect, Your Honor.
All right, Detective Booth, you can step down. And any additional witnesses from the state?
Yes, Your Honor. The state calls Dr. Mac LaGreca to the stand.
All right, Dr. LaGreca, remind you that you've previously sworn to tell the truth. You may proceed when you're ready, Ms. Phelps.
Thank you, Your Honor. Good afternoon, Dr. LaGreca. Could you just introduce yourself to the jury?
Hello, my name is Dr. Mac LaGreca.
And what do you do for a living?
So I'm a fellowship trained forensic psychiatrist, and I'm also the program director of the Forensic Psychiatry Fellowship at the West Carolina School of Medicine.
Let's talk a little bit about your education. Where did you get your undergraduate degree?
I went to undergrad at the University of Delaware, where I studied chemistry.
After that, where did you go to medical school?
At the University of Pennsylvania.
And for those of us that may not know, could you briefly describe what education is required after medical school, if any?
Yes, so after medical school, all doctors who want to practice clinical medicine decide a specialty, and they do a residency training, which is a generalized training in that specialty. So I chose to go into psychiatry, and I spent 3 years studying all different types of psychiatry, inpatient, outpatient, everything. And then after that, if you'd like to further subspecialize in your specialty, you can do further extensive training on a specific area. So I then did a year of forensic psychiatry, which is a field of psychiatry.
And after you finished your education, what did you do?
I opened up my own private practice and did that for 23 years.
And you mentioned a minute ago, but what is your current occupation?
So I'm currently the program director of a psychiatry fellowship.
Do you still treat patients as a program director?
Yes, I do. I have treating privileges at the hospital.
Could you just briefly tell us why you chose to devote your entire education and career to forensic psychiatry?
Yeah, I always knew I wanted to
Objection,
talk, but I found
relevance.
it very interesting, and I really
Objection.
Sorry, just one moment, Dr. LaGreca. We have an objection. Ms. Phelps, what's the relevance here?
Your Honor, I'm simply qualifying my expert and just asking her why she chose to devote her years of medical experience to this field of forensic psychiatry.
Ms. Salvatore, I think that this is still, pretty minimally biographical, but if it goes much further, feel free to renew your objection. So objection overruled. You may proceed, Ms. Phelps.
Dr. LaGreca, would you like me to ask the question again?
Yes, please.
Why did you choose to devote your education and career to forensic psychiatry?
Like I said, I'm very interested in the law and medicine, so I really am interested in how they both go together, and I love psychiatry because I love treating patients with mental disorders and feel that they need strong advocates.
Do you have any special distinctions or honors?
Yes, so I'm board certified to practice psychiatry in 3 states, and I'm also board certified by the American Board of Psychiatry and Neurology.
Now, what were you asked to do in this case?
So in this case, I was asked to review everything in connection with this case and give an opinion on Timothy Ray's mental health and make a diagnosis.
And before getting to your opinions, did you come to an opinion in this case?
Yes, I did.
What materials did you review to come to?
All of the exhibits in the joint exhibit list and everything else in connection with this case, including Dr. Riley's most recent evaluation.
And did you have enough factual bases in these materials to come to a reasonably medically certain opinion?
Yes, I did.
And this is the type of evidence that experts in your field generally rely on?
Yes.
And are all of your opinions you're here to give today based on a reasonable degree of medical certainty?
Yes.
Your Honor, at this time, we tender Dr. LaGreca as an expert in forensic psychiatry.
Ms. Salvatore, any objection?
No objections, Your Honor.
All right. Dr. LaGreca is received as an expert in forensic psychiatry. You may proceed.
Dr. LaGreca, can you briefly tell us your overall conclusion in this case?
Yes, my overall conclusion was that the defendant was malingering and that the defendant did not have schizophrenia.
Now, you just mentioned malingering. Let's talk about that. Can you explain to us what malingering is?
Yes, so malingering is when a patient fakes or exaggerates their symptoms in order to be diagnosed with a mental illness, and usually it's in the context of some sort of external gain.
How do psychiatrists evaluate a patient for malingering?
So a psychiatrist looks at all of the interview factors, everything from the history and physical, and then they make the diagnosis based on the DSM standards.
What is the DSM?
So the DSM is the Diagnostic and Statistic Manual for Mental Disorders. The most recent edition is the 5th edition, and it's basically the gold standard of every psychiatric condition that all doctors use to diagnose a patient.
How reliable is the DSM?
It's extremely reliable. Everyone in medicine, not just psychiatrists, believe that this is the gold standard.
Your Honor, at this time, I'll have my opposing counsel bring up a demonstrative that was previously disclosed to opposing counsel with the DSM-5 malingering factors.
And Ms. Salvatore, before we show this to the jury, do you have any objections to this demonstrative?
No, Your Honor, we agreed to it prior to trial.
All right, you may show that demonstrative to the jury, Ms. Phelps.
Thank you. So for malingering, Dr. LaGreca, what's something you look for?
So we need to consider the context of the interview.
And did you find that present here, or could you briefly explain what you found?
Yes, so in the evaluation made by Dr. Riley, this is in the context of the murder charges. The defendant, Timothy Ray, is facing years in prison for this.
What else do you look for malingering?
So we look for a discrepancy between the patient's claimed stress or disability and then also the objective findings.
And I'm going to backtrack real quick. It'd be accurate to put a check mark for the first factor. Sorry.
Yes, it would.
And for the second factor, did you find that here?
Yes, we did.
Objection leading.
Objection overruled. You may proceed, Ms. Phelps.
Did you find that factor here Dr. LaGreca?
Yes. So during the interview with Dr. Riley, Timothy Ray said Nathan had smashed his personal laptop. However, the objective evidence showed that Nathan had spilled apple juice on his work laptop, which is a clear discrepancy.
Would it be accurate to put a check mark next to this factor?
Yes, it would be.
What else do you look for?
So we look for a lack of cooperation between either the diagnostic evaluation or complying with the medical treatment that's prescribed.
Did you find a lack of cooperation here?
Yes. So a few times in his interview with Dr. Riley, when pressed on certain subjects, the defendant would lash out or have an angry outburst.
Would it be accurate to put a check mark next to this factor?
Yes, it would.
What else do you look for?
We can look for the presence of an antisocial personality disorder.
Did you find that factor here?
I can't say for sure if he did or did not have this, but I did not see any evidence of that specific disorder.
So in looking at these factors, how do psychiatrists determine if someone is malingering?
So we look at these factors, and you only need basically any combination of these factors to diagnose it. So according to here, he had 3 of the factors, and we take everything into account into what he said and can make a true diagnosis of malingering.
In your opinion, was the defendant malingering?
Yes, he was.
Now, you mentioned schizophrenia earlier. Let's talk about that. Can you briefly describe what schizophrenia is?
Yeah, it's a psychiatric disorder in which people interpret reality abnormally.
How do you go about diagnosing someone with schizophrenia?
So we use all of our knowledge from medical school and residency and beyond, and we look at the symptoms that is being reported and that we can objectively see from the patient, and we compare those to the DSM-5 diagnostic criteria.
What requirement, if any, of the symptoms you look for is there to find schizophrenia?
So we look for 5 symptoms, and the requirement is that 2 symptoms must be there out of the 5 for at least 1 month or longer.
Why is there a time requirement of 1 month or longer?
So the time requirement's there because isolated incidents of even any of these symptoms does not mean someone has schizophrenia. These symptoms could pop up from sleep exhaustion or anything. So schizophrenia is a chronic illness. So if a patient has schizophrenia, these symptoms need to be significant and present for around a month, or what we like to say, 1 month.
How strict is this 1 month period?
It's pretty strict. There would be a significant difference between someone experiencing symptoms 1 or 2 days versus like 28 or 29 days. But what we'd like to say is most days in a month.
Now, what's one symptom you look for in diagnosing schizophrenia?
We look for delusions.
What's another symptom?
We look for hallucinations.
Any other symptoms?
Yes, disorganized speech.
Any other symptoms?
Yes, we look for a grossly disorganized or catatonic behavior.
Is there anything else you look for?
Yes, the last one is we look for negative symptoms.
Now, in applying these symptoms to the defendant, do you think it would aid your testimony to the jury if we took these symptoms and made a checklist and a chart?
Yes, that would be very helpful.
Now, can you see this chart in front of you, Dr. LaGreca?
Yes, I can.
Looking at the first column and everything you reviewed, did the defendant claim to have any delusions after his arrest?
Yes, the defendant claimed delusions after the arrest.
Would it be fair to put a check mark there?
Yes.
Did the defendant claim to have any hallucinations after his arrest?
Yes, the defendant claimed hallucinations after his arrest.
Would it be fair to put a check mark there as well?
Yes.
Did the defendant claim to have any disorganized speech after his arrest?
No, he did not.
Would it be accurate to put a check there as well? Or an X there, excuse me.
Yes, an X would be appropriate.
And did the defendant claim any grossly disorganized or catatonic behavior after his arrest?
No.
Be accurate to put an X there.
Yes.
And lastly, did the defendant claim or have any negative symptoms after his arrest?
Yes.
Be accurate to put a check mark there.
Yes, it would.
Now let's move back in time and everything you reviewed. Was there any corroborating evidence of delusions before his arrest?
No.
Be accurate to put an X there.
Yes.
Objection, lack of foundation.
How so, Ms. Salvatore? Say more.
This witness has not explained how she arrived at each of her individual analyses as they go through this chart.
Ms. Phelps?
Your Honor, I'm asking Dr. LaGreca if in everything she reviewed, the materials she reviewed as she testified to earlier, if she found any evidence of these, and she is gonna, I anticipate she'll use what she testifies here to come to explain her opinion on whether or not the defendant has schizophrenia.
I believe there's sufficient testimony on the record, Ms. Salvatore, to indicate that Dr. LaGreca would have had some materials to reach these conclusions, but certainly feel free to address any of this on cross-examination. Objection overruled. Dr.
LaGreca, were there any, in everything you reviewed, was there any corroborating evidence of hallucinations before his arrest?
No.
Would it be accurate to put an X there?
Yes.
Is there any corroborating evidence of disorganized speech before his arrest?
No.
Be fair to put an X there?
Yes.
Was there any corroborating evidence before his arrest of grossly disorganized or catatonic behavior?
No.
And it would be accurate to put an X there?
Yes.
And lastly, was there any corroborating evidence of negative symptoms before his arrest?
Yes, there was. He was diagnosed with generalized anxiety disorder in the past, and that diagnosis includes negative symptoms.
Be accurate to put a check there?
Yes, it would.
And so looking at this chart and everything you reviewed, did the defendant have schizophrenia?
No, he did not.
Why not?
So he did not meet the DSM criteria of 2 or more symptoms for longer than 5 weeks. And even if there were some evidence that maybe he had hallucinations or delusions, they weren't present for at least 1 month or longer, which would make the diagnosis clinically significant.
Thank you, Ms. Golden. You can stop sharing the screen. Lastly, Dr. LaGreca, I'd like to talk about the effects of schizophrenia. What are some effects of having schizophrenia?
So it can vary from patient to patient, but when they're experiencing symptoms of schizophrenia, they believe they're in an alternate reality almost.
What are some effects of having severe undiagnosed schizophrenia?
So an effect of a severe undiagnosed schizophrenia is having a psychotic episode where they can't understand right from wrong.
And in your professional opinion, did the defendant have severe schizophrenia on October 17, 2018?
No, he did not.
And in your professional opinion, did the defendant even have a case of schizophrenia on October 17, 2018?
No, he did not.
Pass the witness, Your Honor.
All right, Ms. Salvatore, you may proceed with cross whenever you're ready.
Yes, Your Honor. So, one moment. Hello, doctor. I would just like to start off by asking you a few questions about the DSM. I know you already talked about it earlier, but let's go over it. You know what the DSM is?
Yes.
You use the DSM?
Yes.
Everyone uses it?
Yes.
The DSM is the gold standard.
That is correct.
It helped you to develop your conclusions.
Yes, it did.
And the DSM outlines the symptoms of schizophrenia.
Correct.
And you agree that those symptoms are accurate?
Yes.
And you listed those symptoms as delusions, hallucinations,
yes,
and negative symptoms?
Those were 3 of the 5, correct?
But you provided no explanation earlier as to how you came to your conclusion regarding whether or not Mr. Ray had or had not experienced delusions, yes? On your direct examination?
Yes, that is correct.
And you provided no explanation as to whether or not he was or was not experiencing hallucinations.
So from
yes or no, doctor? Doctor, yes or no? You provided no explanation on your direct earlier as to whether or not he was or was not experiencing hallucinations.
No, but I'm happy to talk about it right now. If you would like.
Thank you. And let's talk a little bit about negative symptoms. You did not provide an explanation earlier on your direct about whether or not Mr. Ray was or was not experiencing negative symptoms.
I did say Mr. Ray was experiencing negative symptoms. I said he was previously diagnosed with generalized anxiety disorder, which includes negative symptoms in that diagnosis. So I do believe that he did experience those.
Okay, thank you. Let's talk a little bit about the military. You know who Dr. Riley is?
Yes, I do.
Dr. Riley is a forensic psychiatrist.
Correct, so am I.
Dr. Riley did serve in the military.
Yes.
She served in the military as a forensic psychiatrist.
Yes, and we are grateful for her service.
And Mr. Ray also served in the military.
Yes, he did.
But you have never served in the military.
No, I have not.
You have not studied how the military trains their soldiers.
As a part of a psychiatric residency, we do study veterans, especially in connection with PTSD and things like that. So as a part of a generalized residency training, we do study some disorders that are disproportionately affected by people in the military.
But you have not exclusively studied the effect that the military training has on individuals.
No, I would not say that I have.
Okay, so you don't know what basic training is like.
I've never been to basic training, so no, I don't know specifically what it's like, but I have a general idea.
And you don't know the impact that these soldiers face when going through basic training. Yes or no, doctor?
No, I don't have firsthand experience of the impact they face.
And you do not know how the Army teaches their soldiers to manage their stress.
No, I do not.
Okay, let's talk a little bit about Seroquel. You know what Seroquel is.
I do. It's an antipsychotic drug.
And it can be used to treat schizophrenia.
That is true. However, it can be used to treat a wide range of psychiatric disorders, including bipolar, and there's other ones as well. So it's not mutually exclusive for schizophrenia.
So that is a yes to my question.
Sorry, your question was, can it be used to treat schizophrenia?
Yes.
Yes, it can be. Yes, it can be used for that.
And you are aware, yes or no, that Mr. Ray has been provided a prescription for Seroquel?
Yes, I'm aware.
Okay. Now, let's go over those DSM factors again regarding schizophrenia. They include delusions.
Yes.
And you would agree that paranoia can manifest as a type of delusion?
Yes, I think delusions are a bit more fixed and firm than just paranoia. I think anyone in the world can have paranoia.
Doctor, yes or no? You would agree that paranoia can manifest as a subset of delusions?
Severe paranoia, yes, could be considered delusional.
Okay. And you would agree that, again, hallucinations are a symptom of schizophrenia?
Yes, they are.
This would include auditory hallucinations?
Yes, as well as visual.
Okay. And you would also agree, that let's talk a little bit about hypotheticals now. You know what a hypothetical is?
Yes, I do.
Okay. I'm going to pose a number of hypotheticals to you. For these hypotheticals, I want you to assume that there are no external factors or considerations that you may otherwise think of. Do you understand?
I'll do my best.
Okay. The first hypothetical is, assuming that someone is experiencing severe delusions over the course of about 10 years, you would agree that they are probably mentally ill?
If it's just delusions alone, that's not enough to make a diagnosis. We need to take everything into consideration to make the diagnosis of schizophrenia. So just delusions alone, I would not say so. If there's more contextual evidence, then maybe.
Would you agree that it could be a symptom of a mental illness?
Yes, it could be a symptom.
Okay. Now, the second hypothetical is, now assume that someone else is experiencing auditory hallucinations over the course of about 24 years. Would you agree that they are probably mentally ill?
That is a symptom of a mental illness, but you need other symptoms to say that they are mentally ill.
Okay, so you would assume that it could be a symptom, You would agree that that person suffering from that symptom of auditory hallucinations over a period of 24 years could be a symptom of a mental illness?
Yes, it could.
Okay. Now, assume that someone is experiencing visual hallucinations over the course of about 24 years. You would agree that that could also be a symptom of mental illness?
Yes.
Okay. Now assume that someone is experiencing these three symptoms over the course of 24 years. You would agree that that person is mentally ill?
Yes, I would. However, in this case, I don't think it applies.
Yes or no? Yes or no, doctor?
Yes, in this hypothetical situation, not in our case, that would apply.
Okay. Now, I want you to assume that Mr. Ray has been experiencing hallucinations, both auditory and visual, and delusions over the course of 24 years, barring all external factors and considerations. Do you understand?
Yes, however, I don't think it's appropriate to make a hypothetical situation out of a real situation when you're using the real person's name. So
Doctor, it is not your job to determine what is and is not relevant in this hypothetical. I'm asking you whether or not, under the assumption that Mr. Ray has been experiencing all three of these symptoms over the course of 24 years severely, would make him mentally ill.
That is not what I personally believe to be true, but in this hypothetical situation, if that is what we are saying, then yes.
So that would be a yes to my hypothetical question, in which you are assuming that Mr. Ray is experiencing hallucinations, both visual and auditory, and delusions over the course of 24 years, correct?
I'm sorry, I don't know if I'm making myself clear. Hypothetically, yes, that would be true, but I don't think that is the fact in this case. That's what I would like to say about that.
Okay, I understand that. I am asking you a hypothetical. You understand what a hypothetical is, correct?
Sure.
Okay, so assume again, barring all external considerations, that someone is experiencing, that Mr. Ray is experiencing all of these symptoms, hallucinations, both auditory and visual, and delusions over the course of a period of 24 years. They would probably be mentally ill.
Like I said, yes, but I think it's more appropriate to talk about this as the real situation, not some hypothetical situation. If you'd like to ask me about the real situation, I would love to comment on that.
Your Honor, I would like to strike everything as non-responsive to yes, as that does not answer, as the latter portion does not answer my question.
All right, we will strike that last explanation there, Dr. LaGreca, and I'll instruct the jury to disregard that. Let's do two things. Ms. Salvatore, make sure to ask a clear question to the witness. Dr. LaGreca, try to give a clear answer. Ms. Phelps, if she wants to, can ask you for an explanation on redirect examination. But Ms. Salvatore, let the witness answer, and Dr. LaGreca try to give an answer to the question.
My apologies.
Your Honor, I have no further questions for this witness.
All right. Ms. Phelps, any redirect?
Yes, Your Honor. Dr. LaGreca, is malingering an important consideration for forensic psychiatrists?
Your Honor, objection outside the scope of direct, excuse me, outside the scope of cross.
Ms. Phelps?
Your Honor, I anticipate that the witness will explain in response to my question that schizophrenia and making an affirmative or a negative diagnosis in that they didn't have schizophrenia goes directly to malingering. They go hand in hand. I'm just trying to elicit that testimony, in which was talked about on cross-examination.
Ms. Salvatore, correct me if I'm wrong. You did ask some questions about potential symptoms of schizophrenia on your cross-examination. Isn't that correct?
I did, but I asked no questions about malingering, and I asked that if opposing counsel is going to inquire into the symptoms themselves, that she restrict her redirect to that.
All right. Typically, we would have the court reporter read back to see how close this was to a cross-examination question, but Ms. Phelps, I'll give you sort of limited leeway here. Objection overruled for now.
I can rephrase my question, make it more clear. Dr. LaGreca, how, if at all, are schizophrenia and malingering related?
So malingering is a diagnosis of exclusion, which means that you can only diagnose this after you rule out other things. And I have ruled out schizophrenia for Timothy Ray, and I have applied the DSM criteria to malingering. Therefore, that is what I think applies here.
I have no further questions, Your Honor. May this witness step down and be excused.
All right, Dr. LaGreca, you may be excused.
Thank you.
And at this time, are there any additional witnesses or any further evidence from the state?
No, Your Honor, the state closes its case in chief.
All right, any motions from either party at this point?
Yes, Your Honor. At this time, the defense moves for a judgment of acquittal pursuant to Rule 29 of the Federal Rules of Criminal Procedure. So under Rule 29, the defense is entitled to a judgment of acquittal because the prosecution has produced insufficient evidence of intent to sustain a first-degree murder conviction. The state's burden in this case requires them to prove first, consideration to kill, second, a decision to kill, and third, the killing arising from that decision. And the state has produced zero evidence that Mr. Ray planned the death of his son. Officer Booth did not testify that, and neither did Dr. LaGreca.
Ms. Phelps, your response.
Your Honor, respectfully, I believe in the packet, the elements for murder that are going to be in the jury charge that you'll be giving the jury are that we have to prove beyond a reasonable doubt is that Timothy Ray caused the death of Nathan Ray with malice of forethought, and malice of forethought can be one of two things. Either the defendant intentionally, willfully killed Nathan Ray, or that he did so with callous and wanton disregard for human life. Premeditation or plan is not one of those required elements, Your Honor.
All right, well argued, both parties. It will come as no surprise to anyone, I am sure, that I don't think anyone has ever granted a Rule 29 motion in this jurisdiction, and I won't be the first, but well argued. With that, let's take a brief break, and timekeepers perhaps coordinate with each other just to make sure that we're all squared for the second half of the trial. Let's try to come back at 56 after the hour. So let's take 4 minutes, 56 after the hour, wherever you are. Thanks so much. All right, and as folks start coming back into the courtroom, it looks like I have a note here that the prosecution has 18 minutes and 6 seconds left and that the defense has 31:33. Have both timekeepers conferred about those numbers, or is this just the time from one side?
Yes, we're in sync.
Terrific. Thank you so much for doing that.
Your
All right,
Honor.
we'll wait.
Sorry. My co-counsel is in the waiting room, I believe, if you wouldn't mind.
Oh, of course.
Thank you. She got kicked out.
I think we might have a constitutional problem if defense counsel can't be in the courtroom. So she is hopefully back in now. There we go. Perfect. And Ms. Phelps, is everyone here for the state?
Yes, Your Honor.
All right. Let me just take a look to make sure everyone, looks like we still have our 3 jurors. Terrific. Okay. The Rule 29 motion for acquittal having been denied, it looks like we've conferred on time. All sides seem squared away there. Defense, do you have any evidence to present?
Yes, we do, Your Honor. The first witness we would like to call is Officer Peyton Wentz.
Right. Officer Wentz, remind you that you've previously sworn to tell the truth. And Ms. Salvatore, you may proceed when you're ready.
Yes, Your Honor. Good afternoon. Would you please introduce yourself to the court?
Sure. My name is Officer Peyton Wentz, and for about 2 years now, I've been a police officer in Stoughton County.
And what do you do for a living?
I'm a police officer in Stoughton County.
And what training did you undergo in order to become a police officer?
All different types. I went to the academy, of course, and there we did firearms training. We learned about the laws in Stoughton County. We did mental health training, things like that.
Would you tell us a bit about your mental health training?
Sure. So we were trained in the academy to be able to identify certain symptoms that people that we come into contact with suffer from, whether it be during an arrest. And when we learn how to escalate those situations, it's important to understand what disorganized speech, paranoia, non-responsiveness, the importance of all of those things.
Okay. And could you tell us a bit about what mental illnesses you learned about?
Sure. I mean, we learned about all different ones, but I remember specifically we learned about psychosis and schizophrenia.
When have you used that mental health training?
Oh, we use it all the time on the field and in the field, whether it be making an arrest, like I said, or on the street.
Would you provide a specific example as to when you have used that mental health training?
Sure. I used my training in this case involving Timothy
Objection,
Ray.
Your Honor. This is an improper lay witness opinion under 701. I believe she's going into testimony about utilizing a specialized training after 2 years of being on the force.
Ms. Salvatore?
Your Honor, we are not using this to elicit improper testimony. I'm simply using it to lay foundation as to what the witness observed and saw during her interaction.
All right, I don't think that anything's been said quite yet that would draw an expert opinion, but certainly be on the lookout, Ms. Phelps. Ms. Salvatore, make sure that you keep your questioning to Officer Wentz's observations. Objection overruled at this time.
I'll repeat my question. When have you ever used that mental health training?
I used it in this case involving Timothy Ray.
And would you provide, when was that?
On October 19th, 2018, when I encountered him, I was working the sobriety checkpoint.
And who was him?
Timothy is the defendant in this case.
Okay. And what day was that?
That was on October 19th, 2018.
Okay. Now, what was your first impression of Timothy Ray?
To be honest, when I first encountered him that day and he pulled into the sobriety checkpoint, he was really out of it. From the moment I saw him, he looked completely disheveled. He had stains on his clothing. When he rolled his window down, there was a strong BO odor. His car was a mess. And listen, we pull over people who are intoxicated, but he wasn't intoxicated. He just seemed really out of it.
Would you briefly describe what happened during that encounter?
Sure. So he pulled into the sobriety checkpoint where I was working that night. I asked him for his license and his registration. And once he gave it to me, I was able to then give it to my partner so that he could run the information. But I just really remember him acting strange and really weird.
Would you explain what you mean by strange and really weird?
Of course. He started making some pretty unusual statements. I had introduced myself earlier as a police officer, but he asked then if I was a CIA agent. He then proceeded to tell me that he was a terrorist and that he knew the CIA was after him. And that's what stood out to me as very strange.
What else did you observe during your encounter with Mr. Ray?
I mean, I observed a few things, but I what stood out to me was the fact that all of a sudden he started doing jumping jacks, and I tried to get him to stop, but he wouldn't respond.
What else did you notice about Timothy's behavior that night?
Besides the jumping jacks, he made some other movements that were really unusual. He began to like roll his head around uncontrollably, and he started to like clutch his hands over his ears like he was scared of something. And just like the way he was moving was like almost looked like The Exorcist, that movie.
Would you demonstrate for the jury what you mean by rolling his head around?
Sure, he was kind of going like this, and it was kind of like when you're trying to get water out of your ear in the pool. He would just like start bobbing his head and then moving this way and like looking straight on.
Let the record reflect that this witness nodded her head to one side and then proceeded to roll her head around in circles the way that Timothy Ray did on October 19, 2018.
The record shall reflect.
Would you also demonstrate for the jury what you mean by clutching his head?
Yeah, so he put his hands up like this, covered his ears, and like squeezed his eyes shut like this for a while. That's what he did.
Let the record reflect that this witness placed her hands over her ears and shut her eyes the way that Mr. Ray did on October 19, 2018. Now, officer, how long was this encounter?
It felt like a really long time. So I'd have to say, I believe it was like 2 hours or so. And then I called dispatch.
Why did you call dispatch?
For two reasons. So first, I called because after we ran his information, my partner told me that this person was wanted in a missing persons case. So obviously I called dispatch for that reason. I then, based on everything I had just told you about what I witnessed, it really appeared to me that he needed a medic. So when I called dispatch, I explained everything I saw and everything that happened.
Why did you think he needed a medic?
Like I told you earlier, we learned what symptoms to look for from that training from the academy. And Mr. Ray that night pulling into the sobriety checkpoint was, to me, exhibiting all of those symptoms.
And what was it that you noticed that made you think he needed a medic?
Well, like I said, he was making unusual statements about the CIA. His speech was really disorganized. When I asked him to stop moving, he was non-responsive and just kind of looking on as if I wasn't there. He had clutched his hands over his head, which made him seem scared and really paranoid, which we learned to look for. And then once he started doing the jumping jacks, that really solidified to me that this guy was not okay.
Okay. No further questions, Your Honor.
All right, you may proceed with cross when you're ready, Ms. Phelps.
Thank you, Your Honor. Officer Wentz, you'd agree with me that you are not a psychologist, right?
Oh, definitely not. I'm proudly a police officer.
Right, and you'd agree with me you're not a psychiatrist either, right?
A police officer.
Objection relevance, we have already established that this witness is a police officer.
Limited leeway here. Objection overruled.
And Officer Wentz, you are not qualified to make any sort of mental health diagnosis, right?
Absolutely not. Just a police officer.
And lastly, I'd just like to clarify the timeline of events you just testified to. You mentioned that the defendant asked you if you were in the CIA that night, right?
He did, which was very, very strange.
Right, indeed. And he also did a jumping jack, right?
Jumping jacks, yes.
Jumping jacks. And he also did the head roll that you demonstrated for us earlier.
Yeah, like this.
Thank you. I just want to clarify for the jury that these three things you observed after you had taken the defendant's ID and registration, right?
Yes.
I have no further questions, Your Honor.
All right, any redirect, Ms. Salvatore?
No, Your Honor.
Officer Wentz, thank you for coming in and for the acting. And with that, let's hear from any additional witnesses for the defense.
Thank you, Your Honor. The defense calls Dr. Riley to the stand to testify.
Dr. Riley, you're pre-sworn, and Ms. Rao, you may begin.
Thank you, Your Honor. Good evening, Dr. Riley. Thank you for being here with us today. Let's begin by just having you introduce yourself to the ladies and gentlemen of the jury.
Hello, my name is Dr. Riley. I am a forensic psychiatrist with a specialization in military forensic psychiatry.
Are you in the military, Dr. Riley?
Yes, I proudly served in the Iraq War and hold the rank of major, but feel free to call me Dr. Riley.
Thank you. And on behalf of everyone here, I want to say thank you for your service. So you said you're a forensic psychiatrist. Please explain to the jury what that means.
So a forensic psychiatrist is a medical doctor that studies the intersection of mental health and criminal justice system.
Please explain to the jury why you're here today.
I was asked to review Mr. Ray's case.
Dr. Riley, let's go back in time a little bit together. Please describe your education beginning with college.
So I graduated in 1993 with my bachelor's of science in biology. I then attended medical school at the Uniformed Services University and graduated from there in 1997. Following that, I completed a 4-year psychiatry residency at Walter Reed, which is the Army's flagship medical center. And yeah.
And what did you do after completing your residency at Walter Reed?
I began my deployment in Iraq. I was there for a couple of years and then I returned to Walter Reed.
Dr. Riley, are you still at Walter Reed today?
Unfortunately, no. I left in 2015 to form my own practice in forensic psychiatry, and that's where I remain today.
And Dr. Riley, what is your specific area of practice?
So I specialize in providing services to veterans with severe psychiatric disorders.
Why is it important to have a military background when treating somebody who's in the military?
My military background allows me to understand what my patients are going through. Since I have also gone through basic training and have seen the ways in which the Army drills into our heads that asking for help is a sign of weakness, I understand what that's like, and I'm able to kind of navigate past that.
Dr. Riley, do you have any certifications?
Yes, I'm certified by the American Board of Psychiatry and Neurology.
Have you been published?
I've written 15 peer-reviewed articles, 2 of which were about schizophrenia itself.
Have you ever testified in court before as an expert in forensic psychiatry?
Yes.
And how did you get involved in this specific case?
I was contacted by the defense because I had previously treated Mr. Ray in 2010 when he was discharged from the Army due to his mental health issues.
And what were you asked to do in this specific case?
I was asked to perform a psychiatric evaluation of Mr. Ray.
And just a yes or no answer here, Dr. Riley, did you come to a conclusion?
Yes, I did.
And was that conclusion to a reasonable degree of medical certainty?
Yes.
How did you arrive at that conclusion?
So I reviewed my notes from my prior treatment of Mr. Ray, and I also conducted a 3-hour interview of him in 2019. Beyond that, I also reviewed medical file from his primary care physician, Dr. Di Giuseppe. And I also interviewed his ex-wife, Jessica Ray, his father, and his boss.
Is there anything else you used besides what you've already stated to arrive at your conclusion?
I used the Diagnostic and Statistical Manual, DSM-5.
What is the Diagnostic and Statistical Manual?
It's what psychiatrists use to diagnose mental disorders. It is the most authoritative source out there. It's kind of like our law book.
And are these materials that you relied on typically relied upon by other forensic psychiatrists in your community?
Absolutely.
Your Honor, at this time, we offer Dr. Riley as an expert witness in the area of forensic psychiatry pursuant to Federal Rule of Evidence 702.
Any objection, Ms. Colton?
Yes, Your Honor. We object to the generality of the designation. We believe this witness may be qualified, but only in the area of military forensic psychiatry.
Ms. Rao?
That's even better for us, Your Honor, so no objection.
All right, Major or Dr. Riley will be received as an expert in the field of military forensic psychology. You may proceed.
Thank you, Your Honor. Now, Doctor, going forward, please just make sure to answer all your questions to a reasonable degree of medical certainty. And if you cannot, just let me know, okay?
Absolutely.
Thank you. And what is your opinion in this case?
My opinion is that Mr. Ray is a person suffering from schizophrenia, and that he was suffering from schizophrenia on October 17th, 2018.
So let's talk about schizophrenia. What exactly is it?
Quite simply, it's a brain disease that affects a person's overall ability to function.
And what causes schizophrenia?
So we don't actually know for sure. We know that genetics do play a role. If someone's parents or other relative have a mental illness, they're often more likely to develop schizophrenia themselves. Additionally, it also the circumstances in which a person grows up also impacts the schizophrenia diagnosis. A lot of early childhood traumas can lead to the introduction of these symptoms.
And how exactly is schizophrenia different from other types of mental illnesses that you've treated, like depression or anxiety?
Sure. So schizophrenia causes recurrent periods of psychosis. A person with schizophrenia may also have depression and anxiety, which are mood disorders. But in order to have a diagnosis of schizophrenia, they also must have these psychotic symptoms.
And what is psychosis?
So psychosis as a medical condition that causes someone to lose touch with reality. The most common symptoms in relation to schizophrenia would be hallucinations and delusions.
Dr. Riley, please describe for the jury what you mean by a hallucination.
It is when someone sees, hears, or feels something that is not actually there in the environment. Most commonly, people with schizophrenia will see shapes or shadows on the wall. Additionally, hearing voices is a very common form of the auditory hallucinations.
And what exactly is a delusion?
A delusion is a fixed false belief. For example, delusions can be something like, all of my family is replaced by body doubles.
Dr. Riley, how do you diagnose someone with schizophrenia?
So I use the DSM-5, which requires at least 2 of the following symptoms for at least 1 month: hallucinations, delusions, disorganized speech, chaotic behavior, or negative symptoms. Additionally, there has to be an impairment in function, such as relationships or employment.
Dr. Riley, have you prepared any materials that could assist the jury in understanding how you diagnosed Mr. Ray with schizophrenia?
Yes, I did. After I reviewed his file, I prepared a chart and timeline summarizing his symptoms.
Your Honor, I previously disclosed this demonstrative to opposing counsel and there were no objections. So may I please publish it to the jury?
Just to make sure, Ms. Golden, I assume there's still no objections to that demonstrative?
No objection, Your Honor.
All right, you may publish it.
Thank you, Your Honor. Dr. Riley, are you able to see this here on the screen?
Yes, I am.
Please explain to us what the jury sees on the screen here.
So these are the symptoms of schizophrenia as outlined in the DSM.
And you said that a diagnosis requires 2 symptoms. So what symptoms did Mr. Ray have on October 17th, 2018?
So he actually had more than 2 at that time. According to the records, he was experiencing hallucinations, delusions, and negative symptoms. And if you consider the act, I would say the disorganized behavior could also be included.
Doctor, let's go through these symptoms together. When did Mr. Ray start having symptoms of schizophrenia?
So he started hearing male voices when he was around 10 years old.
Doctor, is that typical for when somebody begins experiencing symptoms of psychosis?
So normally when an individual, specifically a male, has schizophrenia, they tend to experience their first episodes of psychosis in their late teens. In Mr. Ray's case, it doesn't really surprise me that he experienced early symptoms of psychosis because he had suffered a lot of abuse from a young age from his mother. For example, she wouldn't feed him, she'd force him to take ice cold baths. And this abuse continued until his mother was institutionalized herself for a mental illness.
Dr. Riley, after Mr. Ray was 10 years old, when did he next experience psychotic symptoms?
In 2010, when he was in the Army, he told his commanding officer that he had been seeing shapes on the wall and that he was feeling depressed, which is why he was medically discharged from the Army. I also know this firsthand because I was the military doctor who treated him and diagnosed him with the depression.
Dr. Riley, you just said you diagnosed Mr. Ray with depression. Why didn't you diagnose him with schizophrenia?
At that time, he only disclosed to me the depressive symptoms. He did tell his commanding officer that he was hallucinating, but he did not convey that to me.
And why didn't he tell you about the shapes he said he was seeing on the wall?
I imagine it's because he just got discharged
Objection,
from
Your
the
Honor. This question calls for speculation.
Ms. Rapp?
I can rephrase, Your Honor.
All right.
Dr. Riley, based on your medical experience and the patients that you've met with, your opinion, why didn't Mr. Ray disclose to you the hallucinations?
Again, Your Honor, this question still calls for Dr. Riley to speculate.
Ms. Rapp?
Your Honor, I'm not asking Dr. Riley to speculate. I'm asking her to base off of the interviews, the clinical interviews that she's had with other patients, and her experience. Why wouldn't somebody disclose that they're hallucinating?
All right, let's ask that question then. Why wouldn't a general patient potentially disclose something, as opposed to why the defendant may have or may not have disclosed something in this particular case?
Sure. So from my experience, a lot of particularly veterans or people in the military have a difficult time disclosing these things. Once again, because of the training that they received, that indicates that, if you ask for help, it's a sign of weakness. Additionally, I had just met this gentleman, and so I wouldn't really expect him to be able to open up to me about something he was embarrassed about, having just been discharged from the Army.
And so after that point in time in 2010, what happened next?
So in 2014, Mr. Ray went to his primary care doctor, Dr. DiGiuseppe. I reviewed her file, and Mr. Ray reported anxiety, depression, and sleeping issues. I also, from my interview with Jessica, his ex-wife, I learned that she wanted
Objection,
Mr. Ray.
Your Honor.
What grounds?
Yes, Your Honor. The foundation of, the factual basis for this testimony is based off of the interview with the defendant's ex-wife. This is an out-of-court statement, and as such, it qualifies as hearsay. And under Rule 703, if the factual basis of an expert's opinion is otherwise inadmissible, the expert cannot disclose the contents of the otherwise inadmissible evidence unless the probative value in helping the jury evaluate the expert's opinion substantially outweighs the prejudicial effect.
Ms. Rapp?
Yes, Your Honor. So this testimony falls squarely within exception to the hearsay rule under 8034, which is the exception for medical diagnoses. Dr. Riley interviewed Jessica Ray as part of her diagnosis of Mr. Ray. And that's a common form of diagnosing somebody with a psychiatric illness, is a clinical interview of the people in their lives. And so this testimony falls squarely within that exception. And to the 703 argument, this testimony surely would aid the jury, considering that whether or not Mr. Ray has schizophrenia, you have to look at his medical history as a whole. And who better to talk about that medical history than Miss Jessica Ray? And I'm going to mute my microphone because of the sound outside.
So just to make sure that I understand, Ms. Rouse, it's the defense's position that notwithstanding the potential hearsay sort of debate regarding Rule 703, this is a statement made for the purpose of medical treatment. Is that correct?
Yes, Your Honor. As part of Dr. Riley's medical report, she went and interviewed the people in Mr. Ray's life, which is common for a psychiatric diagnosis.
Your Honor, may I?
You may.
Thank you. First, as to the hearsay response, the information from the interview, with the defendant's wife does not fall within the medical treatment exception to hearsay. This interview was not done in order to treat Mr. Ray. It was in order to diagnose him within the context of a eventual criminal trial. As such, the same factors that lend trustworthiness to a statement made to a doctor for the purpose of medical treatment in that ordinary circumstance, those aren't present here because these were told to a retained expert for the purpose of their testimony at trial. And second, Your Honor, the probative value of these statements don't substantially outweigh their prejudicial effect. The prejudice is high here because the jury will likely use these facts for the truth of the matter asserted. The jury won't be able to confine the information they hear solely to assessing the expert's factual basis.
May I respond?
You may, briefly, Ms. Rowe.
There's nothing in Federal Rule of Evidence 8034 which says that the medical diagnosis exception to the hearsay rule applies only to non-retained witnesses. It applies to any statements made for the purpose of a medical diagnosis, which here is the statements of Jessica Ray.
The court has looked back at Rule 803 to make sure that that's the case, and I agree. Objection as to hearsay is overruled at this time. Ms. Golden, you can certainly take this up on cross-examination should you choose.
Thank you, Your Honor. So after reporting these symptoms to Dr. Giuseppe in 2014, when did Mr. Ray experience symptoms of schizophrenia next?
So he was having some issues at home, according to his wife, Jessica. She was pushing for him to try to get help from a psychiatrist due to his overwhelming anxiety and depression, but he never did. Then in 2015, we start to see his symptoms get even more severe. The voices returned. They told him Jessica was going to leave him. And around the same time, he started having delusions that Nathan and Jessica were, again, going to leave.
How long did these symptoms last?
They have not gone away because Mr. Ray has not really been treated for his schizophrenia since 2015. His symptoms have only gotten increasingly worse and developed into full-blown psychosis.
And after these symptoms in 2015, when did Mr. Ray next experience symptoms of psychosis?
Sure. So in early January 2018, he stopped showering. I learned from his ex-wife that he would go for weeks without any sort of personal hygiene, which is an example of a negative symptom. He also began to grow more isolated, would lock himself in the bathroom, crying for weeks, would get hysterical at work. All of these are red flags.
And what about the hallucinations? When did those return?
Those returned in 2018 as well, which again isn't surprising because all of his other symptoms were getting more severe.
And what happened during the summer of 2018, Dr. Riley?
So at that point, Mr. Ray did see Dr. Giuseppe for the last time. According to her independent report, she saw a complete change in him. He looked dirty. He accused her of conspiring with his ex-wife to leave him. He accused her of spying on his phone calls, and she really wanted him to seek help immediately.
And what happened after the summer of 2018?
So a few days before Nathan's tragic death, Jessica told Mr. Ray that he wanted a divorce. And after that, we really see him spiral and his psychotic episode begins to peak.
Dr. Riley, what do you mean by that when you say that his psychotic episode started to peak?
Mr. Ray was at the point of his psychosis where only some sort of medical intervention could have really brought him back to reality.
And Dr. Riley, what happened on October 17th, 2018?
So on that day, the male voices that Mr. Ray were hearing convinced him that his biggest fear was true. Jessica was going to leave with Nathan. And so Mr. Ray listened to those voices and punished Nathan in the only way he knew how, which is how we were punished in the Army. He made Nathan do high knees, jumping jacks, running in place.
And what does that signal to you?
That Mr. Ray was in his own world where he was the general and Nathan was the soldier. At this point, he had completely lost sense of where he was and what he was doing.
Dr. Riley, how did Mr. Ray discuss Nathan's death with you?
He told me he would have done the exact same thing even if police were watching.
And just a few more questions here, Dr. Riley. Have you considered whether Mr. Ray is lying about his symptoms?
Yes. So medically, we call this malingering, and I consider this in any court case when I'm asked to evaluate the psychiatric symptoms of a patient.
And did you determine to a reasonable degree of medical certainty whether Mr. Ray was in fact malingering?
Yes, I did. I determined he was not malingering.
And how did you arrive at that conclusion?
Because as you can see from this chart, there are independent sources verifying Mr. Ray's symptoms. He also reported several of these symptoms years prior to getting arrested. For example, auditory hallucinations in childhood. That would have been a very long con. Additionally, he noted, Dr. Giuseppe noted in her independent files in 2018 that he was having delusions. And even Jessica told me about his isolation and crying episodes. So all of these are various independent reports.
Dr. Riley, based on your experience, what will happen to Mr. Ray if he goes to prison?
He will get worse because he's not going to receive the proper treatment he needs. He needs consistent clinical care in order to protect himself and others.
And last question here today, Dr. Riley, can you please restate your conclusions for the jury?
Yes, it is my medical opinion that Mr. Ray suffers from schizophrenia, and he was suffering from a psychotic break due to that schizophrenia on October 17th, 2018.
Thank you, doctor. I have no further questions.
Thank you, counsel. And Ms. Golden, you may proceed when you're ready.
Dr. Riley, you're familiar with malingering, right?
Yes, it's in the DSM-5 as I discussed.
You know that malingering means faking symptoms?
Yes.
And you know that patients do sometimes fake symptoms?
Yes, I do.
To get out of work?
That's one example.
To avoid military service?
That could be another example.
And sometimes to avoid responsibility for a criminal charge, correct?
That is one big concern with malingering, absolutely, which is why I've ruled it out in this case.
You would agree with me that, as you said on direct, in this kind of context, you should always be on the lookout for malingering, right?
Yes, and I was.
You would agree with me that anytime the severity or frequency of a patient's symptoms increase after they're charged with a crime, that indicates malingering, right?
I mean, not always. I understand what you're trying to say, but technically I can't say yes always, but he was also experiencing these symptoms in increasing frequency and severity.
Riley,
murder.
Dr. Riley, I'm speaking generally. You would agree with me that anytime the severity or frequency of a patient's symptoms increase after they're charged with a crime,
it would be a concern, yes.
That increases the likelihood of malingering.
It would be a concern, yes.
For example, a subject in police custody who suddenly begins to act out.
A concern, yes.
And you would agree with me that generally the more serious a crime, the higher the likelihood of malingering.
Absolutely.
Murder is a serious crime, right?
Of course.
In fact, probably the most serious crime a person can be charged with.
Absolutely.
Let's talk about what we know about this defendant before he was charged with murder. You know that someone with severe, untreated schizophrenia, that would impair their daily life, right?
Yes, in the ways that I've already outlined. The negative symptoms would impact their relationships, it would impact their work.
Correct. And a person who has severe, untreated schizophrenia, it would be difficult, if not impossible, for a person like that to hold a steady job, have a good relationship, right?
Correct. You would see their relationships falling apart. You would see them acting out at work, things of that nature.
So let's talk about this defendant and his supposed severe, untreated schizophrenia. This defendant was never previously diagnosed with schizophrenia, right?
He was not. He was previously diagnosed with depression and anxiety, which can be early signs and symptoms of schizophrenia.
Correct. And in fact, he was never diagnosed with, besides what you just mentioned, any other severe mental illness, right?
Yes, again, aside from the generalized anxiety and depression prior to my evaluation, he had not been given the diagnosis of another mental disorder.
He served in the military.
For a brief amount of time before he was medically discharged due to his mental instability.
He has no criminal record.
Not that I'm aware of prior to this episode.
He got married.
He did, yes.
He had a child.
Yes, he did, Nathan Ray.
He held a job at Computerland.
He did. I believe he started acting out at that job as these symptoms were building. So I'm not sure.
Doctor, he held a job. He held a job at Computerland, right?
He definitely held a job at
for years.
Yes.
For years, right?
Yes, yes.
And he was never formally written up at that job, right?
He was not formally written up, but there were complaints made.
There were no formal complaints made to the defendant?
There were no write-ups of the defendant, but there were incidences in which he had acted out at work.
In fact, there was one incident, correct?
Yes, there was.
Where he threatened to kill somebody?
Yes, again, I think this is a sign and symptom of him kind of spiraling out of control.
Because that person wouldn't do what the defendant wanted him to do, right?
I believe that was the circumstances, yes.
And it was only after he strangled his son that he called you.
He did not call me at any point in time.
His counsel called you.
I was asked to evaluate him, yes.
And you diagnosed him with schizophrenia.
Based on the evidence that I put forward, yes, I did.
So let's talk about what we know about this defendant after he was charged with murder. After being charged with murder, the defendant claimed that he had been experiencing all of these symptoms of schizophrenia, right?
A number of which he also complained about before, but yes.
After the defendant was charged with murder, he claimed he began hearing voices as a child, correct?
That was when I was first informed of that experience. I don't know if he ever mentioned that prior to that moment.
In fact, this is the first time a doctor is hearing about the defendant hearing voices as a child, correct?
Specifically about the voices, yes.
In fact, this is the first time any doctor is hearing about any of those other symptoms besides the negative symptoms, right?
Incorrect. I was made aware of the visual hallucinations that he was experiencing when he was discharged from the Army. I just did not.
Let's talk about that, Dr. Riley.
Absolutely.
You evaluated the defendant in 2010, right?
Yes, I did.
That was when he was being discharged from the military.
Correct, for mental health reasons.
And in that interview, he made no mention of visual hallucinations, right?
No, he did not. I was informed of that from his commanding officer, which led to his evaluation by me.
And even more so, when you talked to the defendant, besides what the officer told you, when you yourself talked to the defendant, he expressly denied ever hearing voices, right?
Correct. Again, I discussed possible reasons for that, but correct.
So in opening statement, defense counsel stated that when the defendant was discharged from the military, it was found that he was hallucinating. But that's not correct, is it?
Part of the reason why he was evaluated by me and then excused from the military
Dr.
was
Riley,
because he was
that's a yes or no question. You did not find the defendant was hallucinating in 2010.
I did not, but it was part of the reason why he was discharged, which was your original question.
Okay. He just told you in 2010 he was feeling anxious, right?
He also had very significant depressive symptoms.
Right. He was having trouble sleeping.
Yes, he was.
He missed home.
Yes, I believe so.
And these are common things for military members to experience, right?
Absolutely. So what makes it uncommon is the fact that he was hospitalized because they were that severe and significant.
Right. But these were the only symptoms that he disclosed to you.
Those were what he disclosed to me. Those were not the only symptoms that led to his hospitalization.
So you hospitalized the defendant based on symptoms he didn't tell you about?
We hospitalized the patient in order to evaluate his mental state, given the symptoms that he disclosed to his commanding officers. It's common practice.
Which he denied, right?
Upon his evaluation, he denied them to me, which is why he was not diagnosed at that time of schizophrenia, but he had admitted them to his commanding officer, leading to the hospitalization. Missing home is not a sufficient enough reason to hospitalize someone.
So because of these symptoms that the defendant told you, you diagnosed him with generalized anxiety, right?
Yes, and depression.
And you said also on direct that, excuse me, I want to move to what you've testified to on direct. You stated that the defendant exhibited some symptoms or some signs of disorganized or catatonic behavior, right?
Yes.
That wasn't in your report anywhere, was it?
I think it's evidenced by the fact that he murdered his son during a psychotic break.
But that didn't really answer my question. You didn't specifically mention in your report any symptoms of any sign of disorganized or catatonic behavior, right?
His disorganized speech was evidence in the transcript of my interview with him, which was present in the packet.
But you didn't discuss that in your report, right?
I didn't feel necessary because the full transcript was, again, presented.
So the fact that you're mentioning this for the first time now, we just have to take your word for it.
I believe taking my word for it is the reason why I'm here. I'm an expert in this field, as we've discussed, and I interviewed the individual. The transcripts are available for anyone to read through if they so choose.
You also testified that only medical intervention would have been able to bring the defendant back to reality once he started experiencing this schizophrenic break, right?
Yes, it's not something that you can sit down and calm down. It's something that once you're in a psychotic break, it's overwhelming, it's overpowering, it leads your thoughts into action.
Dr. Riley, you reviewed all of the joint exhibits, right?
I did.
You saw the screenshots from the defendant's phone the day after he killed Nathan?
Yes, I did.
And your opinion for this jury today is that the day after the defendant strangled and killed his son, he was still in a psychotic break where he didn't know which reality he was in.
Regardless of which reality he's in, if you're confronted with a dead body and you don't know why, it is very common for an individual to panic.
You would agree with me. You also testified on direct that the defendant shouldn't go to prison because he needs to be treated.
That is why we're here today. He's
You'd
not
agree
well.
with me. You'd agree with me that he's currently in jail receiving treatment, correct?
He is. He's receiving Seroquel, an antipsychotic for his schizophrenia.
And Dr. Riley, you would agree that just because someone loses their temper, that doesn't mean they have schizophrenia.
Correct. There needs to be the other signs and symptoms that we've discussed.
Ask the witness.
Any redirect, Ms. Rowe?
No, I have nothing further, Your Honor. Thank you.
All right, Dr. Riley, thank you for coming in. You may now step down from the witness box.
Thank you.
Constructively. And do we have any additional evidence from the defense?
No, Your Honor, we're ready to proceed to closings. The defense rests.
All right, the defense having rested, timekeepers, can we get a time check for closing arguments? And counsel, let's take perhaps a 2-minute break, but come right back since we started a bit late. Timekeepers, let us know how we're doing. All right, folks, do I understand correctly, if the timekeepers are on here, that the prosecution has 5:20 left and the defense has 9:45? Is that correct? Okay, and both timekeepers have agreed to those numbers, I assume.
Yes.
Okay. We'll wait just a second for everyone to come back. Mr. Rao, are you going to be closing for the defense?
Yes, Your Honor.
Okay. And Ms. Phelps, I assume you're closing for the state.
Yes, Your Honor.
All right. So Ms. Phelps, just watch the clock. You've got 5:20 left. If you'd like to reserve some time for rebuttal, you feel free. Your timekeeper can come onto the screen just to let you know if you have a minute or 30 seconds left. No problem with that, but watch that clock. Unfortunately, we can't extend time in this jurisdiction.
Your Honor, at this time, may I request to waive the first part of my opening and reserve the remaining 5 minutes and 20 seconds for rebuttal?
I don't believe there's any rule against doing that in this jurisdiction. Ms. Rao, do you have any objection?
No, I have no objection, Your Honor.
All right, Ms. Phelps, we will reserve the 5:20 for rebuttal.
Thank you, Your Honor.
And Ms. Rao, whenever you're ready, you may proceed.
Mr. Ray is not the man who the prosecution claims that he is. Mr. Ray is not an angry man. Mr. Ray did not lose his temper. He did not plan to kill his son, Nathan Ray. He did not want to kill his son, but he was unable to control what was happening. And that's because Mr. Ray suffers from schizophrenia, a brain disease that was overlooked his entire life, a brain disease that overwhelmed and overpowered him and caused him to do something that no sane person would do, which is killed his son, Nathan Ray. And now the government says that Mr. Ray is lying about schizophrenia. But the fact is, the government is the one who over a decade ago said, hey, Mr. Ray, you're unfit to serve in the military because of your mental illness. 10 years ago, the government said Mr. Ray wasn't right in the head because of his mental illness. And the government is the one who let a man who wasn't right in the head out into public without treatment. The government is also the one whose key witness, Detective Blake Booth, lied under oath when he said that Mr. Ray had never asked him about the CIA. And ladies and gentlemen, Detective Booth apparently didn't think that testimony was important when he was giving that testimony as part of a preliminary hearing in this case, where he knew that that testimony was being used for the first-degree murder prosecution of Mr. Ray. Also, Detective Booth, he didn't think it was important for you, ladies and gentlemen of the jury, to see the video and the audio recording of his interview with Mr. Ray. And Detective Booth, he said you didn't need to see it because it was an open and shut case. He said that you didn't need to see what Mr. Ray looked like. You didn't need to see what he was acting like. And you didn't need to see his demeanor at all. Detective Booth said that this was an open and shut case. And the state endorsed that when they put this witness on the stand to come and testify to you, ladies and gentlemen. And so the question is, if the government is so sure that Mr. Ray is an angry man, and if they are so sure that he just lost his temper, then why are they hiding from their burden? Why are they acting like they have something to hide? I know. It's because the reality is that they know that Mr. Ray has schizophrenia, and they know that this case is about schizophrenia, and it's always been about schizophrenia. And so your decision comes down to one thing and one thing only. It comes down to whether or not you believe that Mr. Ray had schizophrenia, and that's it. Because if he did, then even Dr. LaGreca, the government's own witness, you heard her for herself, she said that if Mr. Ray does have schizophrenia, he can't be held responsible. And so let's now talk about the clear and convincing evidence of schizophrenia. The DSM, the Diagnostic and Statistical Manual of Psychiatry, says that in order to have a diagnosis for schizophrenia, an individual needs 2 symptoms for at least 1 month. And ladies and gentlemen here, if the evidence plugs into the DSM, then you must find Mr. Ray not guilty. You must get him the help he needs if the evidence plugs into this DSM, which it does. Because Dr. Riley diagnosed not just 2 symptoms, but 3. First, the hallucinations. Seeing shapes on the wall. That is a hallucination. Because in 2010, Mr. Ray reported seeing shapes on the wall. But not only that, Mr. Ray has also reported hearing voices. These voices were male, and he'd been hearing them since he was 10 years old. And these voices told Mr. Ray that his wife was cheating on him. And these voices were right. So why wouldn't Mr. Ray believe these voices when these voices told Mr. Ray to do the unthinkable, which was to kill his son, Nathan Ray? Those voices are schizophrenia. The second symptom, delusions. Mr. Ray's schizophrenia took his anxiety that he reported to the Army and Dr. Giuseppe, and it amplified it into delusions and paranoia. It wasn't just, oh, I'm a little bit worried that Jessica might start a custody battle over Nathan. It was, I think Jessica is conspiring with my primary care doctor to take Nathan away and leave. That's a delusion, and that is schizophrenia. And third, the negative symptoms, the depression that Mr. Ray was diagnosed with in 2010. Now, the state just brushes that off like it's nothing, but that's because they know that Mr. Ray reported this over and over again, but it was just overlooked. Another negative symptom was Mr. Ray not showering. As Dr. Riley told you, she learned from Jessica Ray herself that Mr. Ray was experiencing this negative symptom. Jessica Ray also talked about how Mr. Ray locked himself in the bathroom crying. Those are symptoms of schizophrenia. And so, you see, ladies and gentlemen, these symptoms have always been here. You see this right here, the childhood in the Army, that is overlooked. That's what this is, overlooked. Mr. Ray's childhood exemplifies overlooked. No one cared enough to get him help because the only person that could have helped him was his abusive mother. And when Mr. Ray was in the Army and saying he was seeing shapes on the wall, the Army just kicked him out, overlooked. Now, Dr. LaGreca wants you to ignore this, but Dr. LaGreca has no experience in the military. He doesn't know how military works, and she doesn't understand what it's like to be in the military, but Dr. Riley does. And Dr. Riley told you what it's like and the significance of Mr. Ray hearing these or seeing these shapes on the wall and reporting this diagnosis. And now this right here, 2014, 2015, through 2018, that is overlooked and that is overwhelmed because Mr. Ray's symptoms were getting worse. The anxiety and the depression that he reported to his primary care doctor were getting worse. And Dr. Riley told you that Mr. Ray needed medication. That could have helped. This, what we're all here for, could have been prevented, but nobody did anything. Finally, this year in 2018, this is overpowered. This is when Mr. Ray succumbed to the voices he had been hearing since he was 10 years old. And this is when he succumbed to the hallucinations that the Army found him unfit to serve for. And these symptoms, ladies and gentlemen, they're real and they are clear and they are convincing evidence of schizophrenia. And these symptoms are independently verified. So this isn't malingering. Mr. Ray's not making it up. The only person who says that he is Dr. LaGreca. Once again, somebody who has zero experience in how military life affects a person's mental illness. Somebody who didn't even interview the defendant. The fact is, Mr. Ray has been trying to get help his entire life. But everybody turned their back on him. His mother did, his father did, and his wife did. And so now Mr. Ray is turning to you, putting his last chance for treatment in your hands. Who would you turn to if everyone you knew had turned their back on you? And you see, ladies and gentlemen, I know that you don't like Mr. Ray. I know that it's not easy to like somebody who admitted to killing their son. But this case is not about whether or not you like Mr. Ray. It's not about whether you can understand what was going on in his head. And finding Mr. Ray not guilty by reason of insanity is not condoning his behavior. I wouldn't ask you to condone his behavior. And it's not giving Mr. Ray a get out of jail free card. It's getting Mr. Ray the help he's needed since he was a young boy. Because justice in this country isn't holding someone responsible for something that isn't their fault. Justice is getting somebody the help that they need. And justice is getting Mr. Ray the help he's needed since he was a little boy. And since the Army told him that his mental illness was disqualifying. But it's also just more than that. It's also about recognizing that this here, what we're all here for today, it could have been prevented. And so, ladies and gentlemen, you have the power to help Mr. Ray. You have the power to get him the help he needs. But you can only do that if you find him not guilty by reason of insanity. Thank you.
Thank you, Ms. Rao. And Ms. Phelps, you may begin your rebuttal when you're ready.
Members of the jury, defense counsel just came up here and told you a lot about mental illness, the DSM-5 and schizophrenia. But I'd like to bring you back to why we're really here today. What really matters, who was really overlooked in this case. 6-year-old Nathan Ray was strangled to death, shoved inside a trash bag, and left to rot in the woods. Nathan was in the 1st grade. He had his entire life ahead of him to live. But now, because of the defendant's choice to grab a belt and strangle his own son, Nathan will never kick a soccer ball again. Nathan's laughter will never fill the room again. Nathan will never graduate from high school. He won't walk across that stage. Nathan will never apply to colleges or get married. And every day, Nathan's mom has to walk by his empty room. And every day, she's driving in her car. His mom looks in the rearview mirror instinctively, and she sees nobody. Now, not going to stand up here and rehash all the evidence that you saw today. You heard from Detective Booth that the defendant confessed. He confessed to strangling his own son. You saw what was in his car, you saw what was on his phone, and you saw what was in his house. We prove this to you, that he murdered Nathan Ray beyond a reasonable doubt, that he caused the death of Nathan Ray, and he did this with malice aforethought. And malice aforethought can mean one of two things. Either Timothy Ray killed Nathan willfully or intentionally, or that he did so with a wanton disregard for Nathan's life. And surely, beyond a reasonable doubt, putting that belt around his son's neck and strangling him to death is an act with wanton disregard for human life. But instead of focusing on that, the defense is trying to use you, members of the jury. They're trying to use you to abuse this idea that he was mentally ill, that he's trying to use this illness to escape responsibility. He's literally weaponizing schizophrenia, a severe mental illness, so you can give him a get out of jail free card. But members of the jury, you weren't his first option to get away with this. He had 2 others. First, he wanted to flee the country. You saw the screenshots on his phone. He was going to literally leave the country to avoid responsibility for this. But when he realized that wouldn't work, he tried to hide the body. You saw how he tried to bury his son's body, leaving it to rot in the woods of Brandywine State Park. But after he was arrested the next day by Officer Wentz, he tried to figure out one last way to get away with this. So he's here asking you to find him so insane that he didn't kill his son. And it was only then, after his arrest, that anyone, any doctor, has heard of schizophrenia or mental illness from him. Overlooked his symptoms? Certainly not. After his arrest, suddenly he's asking about the CIA. After his arrest, suddenly he's having hallucinations. I ask you, members of the jury, which story is substantially more likely true than not? We know he was trying to escape his responsibility as soon as he killed Nathan. And now, after being charged with murder, he's again faced with responsibility for his actions. He's still trying to flee from it, suddenly claiming to have a mental illness so severe he didn't know that killing his own son was wrong. I'd like to correct something that defense counsel said just a moment ago, that all they had to prove to you by clear and convincing evidence was that he had schizophrenia. But as you'll see on your jury instructions in a few moments that the judge will give you, there's actually two requirements to the insanity defense. First, that the defendant did have a mental illness. And second, that this mental illness was so severe that it rendered him unable to tell the wrongfulness of his actions. You heard from Dr. LaGreca. She explained to you that the defendant was malingering and did not have schizophrenia. But even if you believe Dr. Riley's story, they didn't prove to you with clear and convincing evidence that Timothy Ray had a severe case of schizophrenia. Members of the jury, Timothy Ray claims to have lost his grip on reality, when really, Nathan Ray is dead because the defendant lost his temper and murdered him. And Nathan needs you to do justice. His mom needs you to do justice, and we need you to do justice. Thank you.
Thank you, Ms. Phelps. All right, great job, both sides, all counselors. At this point, we're going to just let the jurors finish filling out their scoring ballots. Everyone stay in the Zoom until we get the all clear that those ballots have been submitted. So jurors, you can fill out and submit those ballots. And once that's been done, we'll just have very brief comments and let you all go on your way. All right, Phil tells me that we're still waiting on one ballot to go in from the round. But if everyone wants to come back on screen and maybe the jurors can join, just so we're ready to go with comments as soon as we get the word. And did all three of you have a chance to submit those ballots? All submitted, okay. I'm not sure where they haven't gotten the third. All right, we have the all clear. Okay, great job, guys. Really, really well done. I hope this was fun. It was certainly fun to watch. I will be very brief and then turn it over to the jurors to each give. We've been asked to try to limit it to one comment per team. So let's try to stick as close as we can to that. From my perspective, I think, kind of overarching comment is just, remember to have fun. Be excited about these kinds of things, especially in mock trial context. It's after 7 o'clock where I am now. We want to see people who are having fun. And I think for any juror, they want to see people who love what they do. So I think, just kind of overarching comment for both teams. From the defense, I thought you guys were terrifically sort of exacting and precise. Particularly, Ms. Rao, I think your cross-examination and the objections that sort of laid the foundation for that cross-examination on direct. I thought that was, absolutely textbook and really fantastic. So great job there. And from the state, I think just as a matter of performance art, I love the movement, the courtrooms that you guys have there, the hand gestures. You had the right sort of level of righteous indignation throughout the trial. So I think, really well done to both of you on the state, just, as a matter of performance. I'm a trial lawyer in New York, love to do this mock trial stuff, and I hope that you guys stick with it. It's rewarding and, really pays off dividends in terms of getting to know a great community of people and the like. So really well done, both sides. And, we can start with any of the three jurors. Perhaps Juror Fuentes, do you want to start us off? You might still be muted.
Yes.
There you go.
Yeah, thank you. So I'll just gonna be brief because we only really have time for so little. Congratulations, everybody, on really strong presentations and great preparation. You're all to be commended. I could talk about all the really good things you did, but I thought it might be more helpful to you just maybe be a little more critical. The prosecution closing and opening, I thought big emphasis on the crime and how horrible it was and how he had done it. But that wasn't really a disputed issue in the case. And I wanted to see more of what was the evidence that backed up his not being insane. Knowing when to quit and controlling the witness. So Raina and Ryan's respective crosses, Raina of the expert, LaGreca, and Ryan of the expert, Riley, good control of those witnesses and getting what you needed from those witnesses. Raina, know when to quit. That hypothetical, you kind of went off the rails, she fought you. I think if you'd have just kind of quit right before that would have been great. Or just focus on what do you need to line up with what Riley is going to say about the catatonic behavior. Finally, just a couple things for pointers to be aware of. Reasonable degree of medical certainty. I must have heard that 3 or 4 times. I forgot to mention, I'm a U.S. magistrate judge in Chicago. Before that, I was a trial lawyer for 20 years. Reasonable degree of medical certainty, it doesn't mean anything. It's misleading and confusing to jurors, and you'll need to figure out some better way to express that because you're going to get an objection if you use it. Victim pain, the mom looking back and not seeing the kid in the car. Many states will say that is improper and that you're appealing to emotion to decide the case. Finally, Zoe, reserving all of your opening closing for rebuttal. Very clever, but not really fair because it meant that the defense had 0 chance to respond to anything that you said. I've seen that done. I actually have argued that it's improper. And as a judge, I've limited rebuttal to far less than the time being given to the to the opening part of the closing. I don't mean that as a criticism of you. I'm just saying, be aware of that. Caitlin and Raina, you should have objected to that or asked for a sir response closing. That's all I had. Thank you.
Thank you. And either juror, whoever would like to go next.
I can do it. I'll be fairly quick. I really enjoyed the energy level by both teams. I felt like people really brought it, even when it got late in the afternoon, I'm sure, or in the evening where you are. I'm sure it got very tiring. So I was very impressed by that. If I had to give two pieces of constructive criticism, I think for the prosecution, it would be less is more. On your directs, I feel like you tried to put in so much evidence that you ran out of time for closing, ran out of time for crosses. And I think it really, hurt your ability to do that. I don't think we needed as many pictures as you tried to put in. I think we could have gotten the impression with less. That being said, those directs were good. I just think they took up more time than you needed. On the cross, I think I beg to differ slightly about the witness control. I felt like the defense lawyers were trying too hard to control the witnesses. I think when you basically scream yes or no before a question, you look scared of the answer. And I don't think as an attorney, you ever want to look scared of the answer. I understand the desire to control because we all want to. And these witnesses weren't always going to be easily controlled. But I think trying to work with their answer might be more beneficial than trying to interrupt their answer or trying to cut it off in the beginning. But really enjoyed both sides. I thought they did a great job.
All right, and I will be quick as well. I would say I enjoyed that round, especially on a 4 p.m. on a Saturday from where I'm at, and it's dark now here. I'll just give you guys some constructive criticism, some minor constructive criticism, because I think the next round is the semi, so you don't really want to hear too much. You've probably heard a lot already. Prosecution, something that to piggyback off what everyone else has been saying, you rely a lot on demonstratives. You have to realize on a Zoom type of trial and sort of a teletrial, when you rely on demonstratives, the screen is focusing on that demonstrative and not on you and your persuasive questioning and how you're presenting that information. So be careful about that. And I think Ms. Phelps, you left up the photo of the child there for a long time on your closing, which I get why you're doing it, but you want to be careful about how long you're leaving it so it desensitizes a jury. So rely on your own argumentative and your own persuasive skills and not on the demonstratives as much. For defense, you guys were playing for your client and defending him to the nth degree, but to the jury, you guys were I would say you were too aggressive, right? You have a person that's admitting to killing someone, right? And the defense is, insanity defense. You have to wear basically kid gloves when you're still presenting that, because at the end of the day, you're still presenting a murder case. And no one is going to feel comfortable like saying, oh, okay, I'm going to give you a shot on a murder case where the person's admitted to it and you're trying to figure out insanity or not. So you have to deal with the witnesses in a much more subdued way, because your aggression will portray over to your client. So be mindful about that. But truly, it was actually a really good round to watch, and I enjoyed the closings and the strategies you guys all employed. It was very good.
Thank you, guys. This was an excellent round, I think, and thank all the jurors. I know that this is a lot of time from your weekend, so really appreciate it. Hope you guys had fun, and the closing ceremony should be starting sometime soon, Phil says. So with that, thank you all, and the court is now adjourned.
Thank you so much.
Thank you all.